Happy New Year, Happy New Year, Happy New Year. Go. Alimbe Mobe Kontona. Good day. Are you guys home yet? Come on home, come on home. I am sorry, a little bit late. Just few minutes. How is everybody doing? Alimbe Mobe Kontona, Happy New Year. I am here again. I welcome you all home. Intermedia Network, we are up. We are up again. Alama Mabela. Sanji Jamala. Happy New Year. Alimbe Mobe Kontonalbe Dunia Daoda. Greetings. Thank you, Jalibali. I'm coming for. Thank you all. We are up again. Today our topic will be, this is it, our final discussion on UDP's election petition. This is it. We have our legal team here. We have our amazing team. I cannot have enough of them. Council is in the building. Yes. If you look up there, they're up. Go, brother Sarjo Barrow Hainan Santojana. Ngai brother, ngai ko New Year munyawanya, vacation o munyawanya. Wife law ebe. Even for some time. He's expecting to eat ebe. There's no ebe for him right now until he finishes duty over here. Tamba.
Yes.
Tamba Safi.
Nisafi Saf Jata Nja, Nisafi Saf from
no
Buma.
Retreat, no surrender. He's back in the building.
No, the reverse gear has broken.
Has broken.
Yeah.
Tamba is back, even though he's busy. I'm telling y'all. He said, I cannot miss this. We have our brother, special boss. That's my boss. That's my boss right there, Melville. He is as busy as, I don't even know what to say. But he said, Binta, no way I will make it. I will not miss a bit. So I welcome the brothers. This is it. We're going to go in detail, divided. UDP's petition was struck out, and we want to take a close look at it. Why? It's not about UDP today. It's about our democracy tomorrow. So many elections are on the way. Why are we looking at UDP's petition? Samadum, we have to look at it. Not understanding. They lay it out for us. I have no question. I will just let them do what they do best. Explain this constitution. Explain how the law sees it. For me, I will say, no, it's not fair. But we will let them do their thing. So I welcome each and every one of you. Assalamu alaikum. Brother Mel.
Yes, ma'am.
Good morning. Afternoon.
Yeah, good afternoon.
Yes, I know you are over there in the evening. I'm 1 o'clock, but it's a bit dark, so it seems to be morning. You are welcome to Binto Media Network. Tamba, you are welcome once again. Mr. Barrow, I welcome you all.
Thank you.
Yeah, the floor is yours, Tamba. You can say hello to the audience.
Hello. First and foremost, my special New Year greetings to our beautiful Binto Jataba. Thank you very much for giving me this platform. To your team who people don't get to see most of the time, but doing a lot of hard work behind the scenes. I appreciate the effort they put in to bring this platform to not just Gambian people, to the world. And to my co-panelists, Melville, Happy New Year. It's already 2 days into 2022. And Sarjo, good evening or good afternoon, wherever you are in the United States. To the viewers of Binto Bantaba Network, I expect you to learn from this program again. If you have any issues, you can always ask. Like I always say, we need to indoctrinate Gambians from the beginning, from nursery school, because some of our engagements are just foul, just wrong. But as we talk, as we dialogue, as we communicate, things will change in time. And that's why I always dedicate to come to this platform. So hopefully people can see how I engage without calling people names. So thank you very much again.
Mel?
Yeah, thank you so much. Happy New Year to all of you. Good evening to all my co-panelists, and of course, a good evening to you, and Happy New Year to each and every one of you. It's been such a long time since I saw Lamin. It's been last year since I last saw him, so I missed him so much. But it's always good to be on your program, on your platform. Like I always say, it's always a teaching and learning moment for all of us. So I'm looking forward to a very fruitful and robust deliberations, and hopefully we'll get to the bottom of whatever issue that we're going to discuss, and we'll learn from each other. And in the final analysis, it's all about Gambia and what we need to have in place to see a very productive and more engaging Gambia for all of us. Yeah, so
Thank you. Sarjo? Barrow?
My apologies, I was on mute. Hello, everyone, and then happy holidays. Greetings to my co-panelists, Tamba, and then Melville, and then I welcome you all. And then I'm looking forward to a productive and then a fruitful session of learning. I'm here to learn too. You know, we can learn from each other, learn from the audience. And then most importantly, I'm not here second guessing or addressing, you know, what the ruling is. And then in jurisprudence, rule of law, we all have to accept, you know, what the court say, you know, because they have the emphatic duty to say what the law is. We can squabble, disagree, or, you know, have opinions as we should, citizens. But at the end of the day, we should all respect the authorities and then challenge it the way the law say it should. Or sometime give us hindsight is not 2020. Discuss these issues to make sure, you know, our lawmakers, National Assembly, that's why they are there. If they think, you know, things need to change, things need to be done, this is an opportunity for them to learn too. And then that's why I think public discussion is important. And then Gambia should engage in it more often, and don't think that is antithetical or, you know, as in our culture, it's being disobedient or rude to the elders.
Okay. Before we start, I'm just viewers. If you have any question, write it out there on the comments. They will all follow the comments. Any question that's very important, they need to address it, they will. So respect. I will open the lines later on, your legal questions. Please, it's not about politics today. It's about the verdict. Okay? Thank you. Sarjo.
Yes.
We want you to talk to us exactly what is contained in that court verdict.
Well, my reading of the ruling first is Supreme Court, the holding is UDP's failure to comply with Rule 11 of the election petition rule render the petition a nullity, and then as such it must be struck out. And then specifically what the court is saying is, although UDP filed within the 10-day statutory period, and then the amended petition was done the right way, and then the court actually finds that service was proper on Alaji Sisi under the original jurisdiction, it nonetheless state that Rule 11 is distinct from the general rules of the Supreme Court original jurisdiction. And as such, UDP must comply with that. And then I believe the specific issue was, in as much as, UDP's lawyers, their counsel emailed the amended petition to President Barrow's lawyers, that email is not going to cure the deficiency of Rule 11. Specifically, the manner or nature of the security cost was never communicated, even though the purported email from the master, my understanding, to all parties is not the same thing as notice. So as such, they have to stroke it out for failure to strictly comply, which render it fatal.
When you heard it was struck out, what was your reaction?
I was disappointed as a Gambian. When I mean by that, let me qualify, because my hope was this case would go forward on the merit, and then importantly, to serve as a seminal case that would at least address, the benchmark for election petition, what the standard of, proof would be, the burden of persuasion, who that should be on, and then what kind of decision would make an election invalid. Is it just a violation or significant violation that somehow, will render the outcome of the race, or any violation of the Election Act should be enough for us to go back to the poll? Because I think that is important. Still now, those questions have not been answered. And then at least that would give us an opportunity. Parliamentary election is, around the corner. And then the mayoral election, I think, is it a year out? So those things are coming. And then now, as Gambians have more confidence in their judiciary, people will be going to court. And then these issues need to be addressed that way. If there is a benchmark, a flaw, at least counsels, lawyers could advise their clients appropriately, rather than saying, we don't know, let's try what's going to happen. You could advise a client, in as much as, you might have concerns for elections or the results, there's a violation here or two, but under the laws as is right now, if we go there, we are going to lose. We don't have enough. At least that's going to put everyone at ease. And then elections, we will know when to go to court and when not to go to court. So that is a missed opportunity, but regarding the strict compliance of the rule, because I looked at this thing at 2-2, I was a little bit shocked too, like how other commentators looked at it. Okay, this is a technical issue, and then why should it be struck out? Should I falter the court? And then I may disagree with the approach, but I looked at the jurisprudence, and then so far I have some issues. But if I want to speak honestly as a jurist, I would say what the court did is not unprecedented. In fact, they are not in the minority. They are in the majority as things stands right now with the way rules are.
Okay. Yeah. Okay. Tamba, election petition is very important.
Yeah.
Just like Sarjo just said, we lost that opportunity. But the importance of election petition, especially this one, 2021, UDP, MPP, and all the rest of the candidates.
Yeah.
Do you really think this verdict was fair?
Well, I wouldn't comment on the fairness, because then we're questioning, we're saying the court is biased in this case. What I would comment on is basically, to be honest with you, legally, I am not happy with the decision. It leaves a bad taste. And of course, I'll cover the reasons why I'm not happy. This is not a personal sentiment that I'm expressing here. So the election petition itself complied with everything except one thing. And that one thing that it didn't comply with is basically who received the security of cost within that 5 days after the petition was presented to the Supreme Court. I think that's the problem here. The Supreme Court agrees that the master of the Supreme Court, or the service of the Supreme Court, or the registrar, did receive the security of cost. The representative of the first respondent did receive a copy of it via email. In the United Kingdom, email is instantaneous communication. If it's served on the party before 4:30 on the day, business day, it's deemed as served that particular day. So we live in a modern world, a lot of case law that they quoted was early 1980s, 1970s, 1960s, and old time where email didn't exist. Yes, the court did say the 5 days was satisfied in many other aspects. It's only one. So the petition itself, when you serve it on any of the parties, it has 3 components. You notify the respondent that you have launched a petition. And then in that notification, you give them a copy of the petition itself. On top of that, you provide security of costs. And the 3 parties in this case is Adama Barrow, IEC, and the Attorney General. Now, they've done everything to everyone, except that the 3 components that were served on Barrow, one of them was missing. All right? The lawyer of Barrow, who's the legal representative, admitted receiving a copy from the UDP. The registrar did receive it. But they're saying the 3rd component, security of cost, was not actually served on Barrow. So there's a lot of technicalities here. Like Sarjo said, we would have loved this case to continue. If serving on the chief of protocol is deemed as served on Barrow, which they accepted in some respect, how come service of another component on Barrow's legal representative is deemed as not served on the first respondent? So there's a lot of things here. So Barrow's lawyer accepted receiving a copy of the security of costs on time via email, and the registrar confirmed it. But what UDP didn't do, according to the court, is serve the same on Barrow himself. So they should have gone back. The other 2 components they served on the chief of protocol, they should have taken the security of costs and served it on the chief of protocol as well. So because that wasn't done, they're saying that didn't satisfy Rule 11 of the election petition rules. So for me, as an individual, learning to practice in this modern world with emails and everything, and in many cases in this country, if somebody is your legal representative and you serve them the documents, in most cases, it'll qualify as service on the client, because what your representative should do is forward that communication to you. Why in this particular case it didn't work, where the Supreme Court had it, Barrow's lawyers had it, but because it wasn't served on the chief of protocol again, or somebody close to Barrow again, the court said Rule 11 wasn't satisfied, as far as I understand. So they accepted a lot of other things, except that security of course was not served on Barrow within that 5 days. And that, for that to absolutely kill a case that we were all anticipating, is a massive loss for all of us learning to practice law and practicing lawyers, and to the general public of the Republic of the Gambia. Because going forward, somebody's going to challenge election results again, and they might fumble along the way. So really and truly, we need to look at our laws again. This is not meaning change the entire constitution. This is meaning looking at all our laws and making them consistent with the way they enforce constitutional provisions. And that's my position at the moment. But I'll go in detail as the conversation goes forward.
Okay. Brother Mel. I see you laughing. Before you respond to Lamin, this Rule 11, we want you to give us an understanding, lay it all out for us, and tell us where UDP lawyers failed to comply.
Okay.
Go ahead.
Because you know me and Lamin when we're on a okay. Would you want to, I don't know if at any point, probably I know Sarjo mentioned that he's got a copy of the ruling, but I think it would be beneficial to the audience. We keep mentioning Rule 11, but we are lawyers amongst ourselves.
Yes, go ahead.
Who we're talking to don't know what Rule 11 states and what it says. So I just think for the benefit, I'll just read it, and Lamin and Sarjo can correct me if I'm wrong, if I've missed anything, but I have my copy is not from what they have. It just says Rule 11 reads, notice of the presentation of a petition and of the nature of the proposed security accompanied by a copy of the petition shall be served by the petitioner. And I want you to pay particular attention to the wordings, shall be served by the petitioner. on the respondent within 5 days after the presentation, exclusively of the day of presentation. Sarjo, am I right? Is that what it reads?
Yes.
Now, Lamin made mention that the registrar sent an email, a notice to state that a security of cost has been deposited. Now, this is what was sent by the court to all the parties, that we are in receipt of a security of cost which was deposited at the Bloomberg account. And the registrar sent this to the various parties to say that we have received this. Now, going back to what Lamin was arguing, Lamin's argument is premised on the fact that the notice of receipt of cost, which in my mind, and I'm wrong, and my learned colleagues can actually give their own verdict with this, but I have been trying to analyze and look at both the language of the learned justices, looking at the language that is in the statute, and just looking at the facts that accompany therein. Now, this amount was paid at the bank. The registrar, by way of that notice, in my view, in my opinion, was confirming receipt of the security of cost. And this email was sent out to the petitioner's lawyers and to the
Barrow's lawyers,
the respondent's lawyers.
Yeah.
Now, the law is that the petitioner is mandated according to Rule 11.
UDP.
UDP should serve on the respondent within 5 days the notice of the presentation of the petition and the notice of and the nature of the proposed security accompanied by the petition. And what this does, that document tells the respondent what has been put down, what surrounds that security, what is the security for, what is expected of the respondent, and the regime, the regulations that are guarding that security.
That's the 300,000.
Yes, and then what this does is it avails the respondent the benefit of either agreeing, disagreeing, or raising whatever concerns that surrounds the security of cost. So this is what the law, this is what the mischief, the rule was not just there in oblivion. The rule had a specific issue that it was trying to correct and alleviate. Now, what the learned justices opine in this judgment is that the notice that was sent out by the registrar does not take away the legal obligation on the petitioner from serving the respondent with the notice of security of cost. The law made it mandatory. The law and the strict application of this, of a strict interpretation of this particular rule by the justices says that they expect that the petitioner must serve within 5 days the respondent. And this is how I understand it.
Okay.
Now, this does not take away, and of course, everybody who I think is a legal person, except maybe the lawyers for the respondent who were happy that the matter was cut short, and of course, they have less work to do. But all of us were looking and expecting that this would have been a landmark judgment whereby, like Sarjo said, like Lamin said, the regulations, the regime, the laws, the expectations, the yardstick, just the common denominator that we would expect to guide our elections, to guide election petitions, would have been made very clear by the learned justices. So yes, we all expected this. But again, substantive reasoning law based on merits, that is a whole different argument, that a legal argument that, I mean, even the most eminent of jurists are divided about. And that is substantive reasoning, substantive matters being adjudicated based on merit, or just on the rules and regulations and technicalities. But if you want to look at it as a lawyer, and I know Sarjo knows this, and I know Lamin knows this, serving the petitioner a particular process and serving that process within a particular time frame, let's say 5 days in this instance, if they had filed the petitioners had brought this action in court, let's say after 15 days, are we going to say as lawyers that the court should have entertained that petition after 15 days, even though the rules say 10 days, because there was substantive evidence in that process to show fraud, to show cheating, irregularities and stuff? No, we would not, because we would all accept that it was out of time. And these are the rules. So if we can accept that, which is not into the substantive reasoning of the matter, it is mere rules and procedure, I think it is in that same breath that we should be able to accept the rules when it comes to service and notice of service.
Yeah,
the two
Melville,
cannot be divided.
Can I cut you for a second? For a second? My only problem here, and I've made that clear, is that the service of the petition itself and the notice on the chief of protocol was accepted as served on the respondent, first respondent. Why then is the nature of the security and the cost served on the legal representative of the first respondent is deemed as not served on the first respondent, and for that matter, the petition failed?
And that is what I just explained.
Yeah.
What I just explained to you is that the first service was done on the respondent by way of his chief of protocol.
Yeah.
The issue with security of cost was not served on the first respondent or his protocol. It was copied. The email that was generated from the registrar as a receipt of cost was copied to the lawyers of the first respondent. So I don't know if you are now seeing the distinction.
I can see the distinction. I can see the distinction. Yeah, I can see.
The first processes were served on the respondent by way of his chief of protocol. And when I came on the program last week, I think we had that argument when I explained to you that because of the nature of the office of the president, it would be deemed that, in my view at the time, this was before the ruling of the Lamin justices of the Supreme Court, that serving the chief of protocol, who is the chief, individual public servant that is as close a proximity to the president as possible, I at that time believed that it was deemed to be effective service, and there was no need for an application of substituted service. I said this in the program last week. And the Supreme Court judges did exactly that. Their interpretation, if you look at the ruling, was exactly that. Exactly what I said. That the service on Alhaji Ceesay was sufficient, along with the deposition of Sidi Njai, accepting that indeed they are aware of what was served on the chief of protocol. Now, the distinction, Lamin, the distinction in this matter is that the petitioner did not, again, go back to Alhaji Ceesay to serve the respondent in the manner which they did the first time. What they did was to copy the email that came from the registrar. Are you seeing the distinction?
I can see
lawyers.
I can see the distinction, but well, when you finish, I'll come to it.
Sarjo, you can come in too. Mel, go ahead and finish. Then Sarjo will come in too.
No, so for me, that is the distinction. And when the learned justices, if you look at the ruling, they delved into it. They mentioned it. They said that cannot be seen as sufficient service.
Yeah.
They said as far as they're concerned that is not service. That the petitioner is mandated by law to ensure that service was effected with respect to the security of cost. And this is the ruling. And to be honest with you, looking at it, I agree. If we are going by the strict applicability of the rules, and then there's one part that I wanted to read in the ruling where the learned justices had said, this was even before the delve into the substantive ruling, that election petitions are a class of their own.
Yeah.
Okay. And that the long list of authorities of the jurisprudence in our jurisdiction is that there should be strict applicability of the rules with respect to time frame, with respect to service, with respect to procedure. And this is what is the authorities that they have relied on. And this is what has happened in our jurisdiction. Be it petitions of presidential elections, of National Assembly, of parliamentary or local council. This has what the courts have always, relied on, the strict applicability and interpretation of the rules.
Okay.
All right. So I have a problem with that, Melville. Service on the president can be by many means. It would have been better for UDP lawyers to keep the consistency. They served the first process on the chief of protocol. It would have been good if they went back to the chief of protocol for the 5-day notice, which is fine, security of course. But if you're serving on the president, if the chief of protocol is not there, or you can't serve on him, the permanent secretary is not there, office of the president, or you can't serve him, the secretary general is not there, who I believe has got very close connections with the president. I'm not too sure about the secretary general, but the permanent secretary, office of the president, can be served. All right. And if you can't do that, if you served it on the first respondents lawyers, in my view, look, I understand what the Supreme Court did here. I don't think the Supreme Court is horribly wrong, but I think they over-interpreted this particular section. You can serve the president via many means, via many portfolio that surround the president. In this particular case, the lawyers of the president, the legal representatives, are dealing with the president directly in this matter. So for me, as an individual, if you served this petition and all its credentials, the 3 components of it, within 5 days on the legal representative of Barrow, the Supreme Court, in my view, for the benefit public interest case in this matter, they could have deemed this as served. Yes, the legal representative is the one that would have been dealing with this 5-day notice anyway. Even if you gave it to the chief of protocol, what the chief of protocol is probably going to do, notify Barrow and send all the material to the legal team. So yes, the Supreme Court said a copy of that registrar's email with the security and nature, of course, was sent to Barrow's lawyers, and the court had it. But what didn't happen was Barrow didn't receive it. And why is serving on the chief of protocol different from serving on Barrow's own lawyers? That's what I don't understand.
No,
this is what, look, I know the rules exactly how they are. If we go by what's happened before, case law and all whatnot, they said those things needed to be complied with strictly. All the 3 components of the petition have to be served on all the respondents. I understand that. But in this particular case, we're dealing with the president. The president can be served via many means. Chief of protocol, permanent secretary, the president himself, the president's lawyers. So why then chief of protocol was appropriate, but the lawyers wasn't appropriate? No, and they're the ones dealing with the president.
Lamin, you're missing a fundamental problem. And I'm not sure if you have read the judgment.
I've read the judgment.
Well, if you had read the judgment, the fundamental thing you're missing is that the question was not whether service on the lawyers was sufficient service enough. That never came up in the arguments of the petitioner. What came up in the arguments put forth by the petitioner? And Sarjo, correct me if I'm wrong, because I'm sure you have read the judgment. Maybe
I'll find a copy of it. Let me find a copy of it.
I'm sure Sarjo had spent a longer time on it.
Yes, Sarjo might have it. Yeah.
The argument of the petitioner. I have just read this probably like 30 minutes ago when I went through the judgment. But the argument of the petitioner
Yeah.
is that Rule 11 did not apply because of Section 49 of the Constitution. The petitioner's argument was that Rule 11 is inconsistent with Section 49 of the Constitution, and therefore, to the extent of its inconsistency, is null and void.
Yeah, that argument didn't.
Lamin,
yeah.
you cannot. I don't understand how you're doing it, but you cannot import. You cannot import into the judgment and the interpretation of the judgment of what is not before the court. The argument of the petitioners was in no time that sufficient service was done, or it was deemed that there was sufficient service when a copy of the memo was sent to the lawyers of the respondent. That was not the argument by the petitioner. And
I'll give you one. Yeah, go ahead. When you finish, I'll come back in.
Yes. And what the courts did was to give an interpretation to say that there is nothing inconsistent with Section 49 of the Constitution and Rule 11.
Yeah.
They said there was nothing inconsistent. They said that they went to explain how the Constitution was the framework, and the rules and all the other things were there to aid, the provisions and to aid the, what's the right word to say? But to aid the what's the right word to say? The fulfillment of the obligations of the Constitution. Now, what you are saying, which I disagree factually, is the fact that when the memo was sent out by the registrar to acknowledge receipt, you are now saying that memo is sufficient service on the respondent. And I'm disagreeing with you. There is no time.
Now, the court actually, there's more to it than just the memo coming from the registrar. There's more to it.
Can you
you go on and I'll find the
let's see if Sarjo had divided it.
Yeah.
Sarjo, do you have it there with you?
Yes, I do.
Okay, please, can you you chip in too? Let's see.
I mean, I understand Tamba's argument, and then this is, Supreme Court in this case, they are sitting as a trial court. They are the finder of facts, and then I don't know what the standard is in Gambia. Maybe, if Melville and then Lamin actually practice in Gambia, you could say if there's a review, courts sometimes get facts wrong, even if they're there, but you could always challenge it. And then the standard is clear error. If you could show that the court actually, the facts are, contrary to what the judge is fine. But in this case, when I looked at the finding of the court, this is where the distinction is. The court is not saying you can serve President Barrow's lawyer. In fact, they considered that on page 39 of the judgment.
Absolutely.
The issue is Section 49 of the Constitution. People have to make this distinction. It only says you have a right to challenge petition. And then if you do, you must do so at Supreme Court. Supreme Court Act says, how do you come to Supreme Court as a, court of first instance, original jurisdictions? And then under the rule there, it says whenever you file a petition, the register must serve that petition. It doesn't put the burden on the petitioner. If you looked at the original jurisdiction of the Supreme Court, and then the first petition, when it was filed, I think process server served that on the chief of protocol, and then the court deemed that full service. The issue, what comes next is when security was paid, whether in bank account, because in the finding that was not, clear to, again, all what we know was on the 16th, UDP made an expiry order for court to assess cost. Court assessed 300,000, including on security. And what it says is, UDP, you have until the 21st to pay this. And then once you do, you must comply by notifying the court that you did. Now, service in Gambia, when I looked at it, the Supreme Court Act doesn't say how service is done in Gambia. The only reference I could find is in the Court Act, the High Court Order. I think Order 3, Section 1. What it says, any literate person can serve on the respondent. And then Supreme Court made it very clear, service on the respondent means respondent person, Adam Barrow. And then they covered an exception for this thing. What is not clear to me, for me, what I want to know, when the master sent out that email saying that 300,000 security was paid, was the master acting as a regular part of, normal course of the business, like you see money come into the account And then like, hey, oh, okay, it appears that this payment is from UDP, and then you are notifying the court that we received 300,000, it's from UDP, and then doing so you copied parties. If that's what happened, the master is just doing his job. There is no way you could argue that is service on the respondent, even if it's to the President Barrow's lawyer. On the other hand, if UDP lawyers instruct the master to serve, one thing people have to understand, when they say petitioner serve, it doesn't mean petitioner could be a corporation. It doesn't mean the corporation is going to wake up and then go serve individual. You know, in as much as you could even have a judge do your service if the rules doesn't prohibit it. So to me, what is not clear in the finding of the fact, was the master acting as an agent of UDP, or was the master just doing his regular normal job? That wasn't clear in the finding and the analysis. But in the analysis part of the judgment, it would appear from my reading, the Supreme Court is saying the master was only sending email to let the court know that UDP complied as part of the ex parte order. If that's the sequence of events, the court's position is that's not service. The court in fact considered, they said, counsel to counsel service of the Second Amendment petition does not cure the deficiency of Rule 11 without, they qualified with an adjective, without the manner and the cost of security, because the court is presupposing that email from the master was just doing his job because there's money into the account or money was paid at the clerk, however the payment was done, because we don't know. The court order says pay to the master either in cash or if there's account, you pay there. So I don't know how the payment was done, but that's where the distinction is. But my reading of the judgment and then the way the facts, even though it was not clear, it appears the court is saying payment was made. Somehow either there was a notification on the master, he saw it, and then the master, as part of the normal course of business, was emailing the court that there is a payment, and in doing so, the master actually copied UDP lawyer and then the Barrow's lawyer. But if the events were otherwise, then Tamba's case, I would say, you cannot say if someone is acting as an agent of another person and then they serve on your counsel, of course, service would be sufficient. But I don't think that's what the court is saying here. And then my understanding of the reading is the master was just notifying the judges that we did receive the money, and then in doing so, copy these other people, which is not going to obviate the petitioner UDP's burden on the Rule 11 to still, notify the respondent. The mistake was when they email, because the second petition was never served on Alaji. We have to understand that. Yeah. The amended petition was served through email, and then the court has no beef with that. But when that email was sent to Barrow's lawyer, it was sent without the manner in which the security was posted. So that's where the court is saying you fell short. Hadn't been it contained that, things would have been okay. So that's how the ruling was. And then I don't think they have more beef with whether it was on Barrow or Alaji Sisi or Barrow's lawyer.
Look, I understand it up to that point, and I understand the court's ruling. I understand what Melville is saying. What I'm saying is, when matters like that arise, where UDP have done everything they could, but for one particular component that was not done properly, you understand, they've sent, okay, so the nature of the security and the $300,000 was deposited cash into the Bloom Bank. The registrars confirmed that, a copy was sent to that. So that particular section, the court did say categorically, I read the ruling and I understand what the Supreme Court is saying. If you complied with about 90%, I would say in this case, maybe 95% of petition all the way, but just one particular thing that was copied to Barrow's lawyers and the court, but Barrow himself was not served. My problem is here now. The court says, I can bring up that paragraph. I've got the document now, the ruling, but I want to bring up that paragraph. If I read it correctly, it stated that the service on Barrow's lawyer and a third party, so the third party here is either Barrow's lawyers or the registrar, not Barrow himself.
No, that's not what it said. That's not what it said.
Okay, let me read the paragraph. Okay. Let me read the paragraph.
The third lawyer was being referred to, the third lawyer that the ruling was being referred to was the registrar.
So and the third party is the registrar here.
Is the registrar. And just like what Sarjo explained, which I just tried to explain before, is that the registrar was simply, the master of the court was simply acknowledging receipt of security of cost. Yeah. Because this money was paid into the Bloom Bank account of the court or the master or whatever it is. Yeah.
Yes.
And what the registrar was simply doing when they got notification of that receipt of that cost was to let the parties know that yes, we acknowledge that there has been made this amount. This amount has been paid. And now what the learned justices have opined is that the notice of the security of cost does not take away the legal burden that Rule 11.
I know that.
Petitioner.
Yeah.
And
I
you
know
said
that.
something. You said something again, which in law,
you
said something which I mean, as a lawyer, I didn't think you would say, but you said something to the effect that the petitioners fulfilled every single aspect of Rule 11 except the bit about the
But that's what I
security
said at the beginning. That's what I said. See, the problem is, I am saying I understand the court's ruling. What I'm saying is, on this particular occasion, my beef is one thing, one particular thing only. One particular thing. I'm not saying this is why.
Mel, check your phone.
Yeah, this
Check
is
your
why
text.
I didn't want to question the Supreme Court's ruling in terms of unfairness. What I'm saying is, although the Supreme Court is not wrong to say the three components of the petition have to comply and have to be served on all the respondents within 5 days. So I done that disclaimer. I said the Supreme Court was right to interpret it strictly that way. What I'm saying is, on this particular occasion, just one thing I disagree with. One thing. If the Barrow's lawyers were served with these documents or petition, I don't know. Let me read the paragraph, by the way, so you can listen to it, and I'll expand on why I am adamant that that particular section of security of cost not going to the first respondent, why I believe on this particular occasion, all right, the court could have allowed this matter to go ahead because I see Barrow's lawyers as adequate service. That is wrong in terms of if the laws are applied strictly. You understand? So I'm saying here, what I'm saying categorically clear is whether the registrar of that Supreme Court or the master, whatever his title is, has had that security, that amount of money deposited with the nature of that security. And if the master of that court copied to the parties involved, maybe the Chris Mena, the lawyers for Barrow, maybe UDP lawyers, whoever was involved here, the registers copied it to them. Let me read the paragraph here and see whether you understand where I'm coming from.
Yeah, but before you read the paragraph, though, because of the benefit of our audience, can we just agree on certain things, on certain facts? You keep insisting and saying something that is fundamentally flawed and fundamentally wrong.
Yeah, because in that particular instance, I know what you're saying, Melville. I know what you're saying. I know what you're referring to here, because Rule 11 says one thing.
No, I'm not talking about Rule 11. I'm not talking about Rule 11. Because you keep insisting that service was done on the respondent. That is fundamentally flawed.
On the respondent's lawyers.
Hang on.
Yeah.
There was no service done on the respondent or on the respondent's lawyers. The facts are before you, Lamin. What was done?
Yeah.
Listen, Lamin, what was done was that a notice, it says it's there, the wording is there. You cannot substitute the word service for notice. The wording is clear, Lamin. And
so let me read that paragraph.
Really smart, but I'm not allowing you to get away with this.
Okay, listen. No. This is the court. This is what the court says. Let me read what the court says for 1 minute.
Okay, Mel, hold on. Let
Lamin read it. Let Lamin read it.
Let me read this paragraph so you can see what the court is saying.
Lamin, do you have the entire verdict with you there?
I've pulled up one on online, so I'm hoping I'm reading the right things. It says in the Superior Court, and it's the parties involved here is talking about. And I'll read this particular paragraph.
Okay.
All right. So it says, in the instant case, so we're talking about the UDP petition. Has the petitioner complied with these requirements of Rule 11? That's what it says. So now, the learned counsel for the petitioner argues that the motion is limited to the question of security of cost in relation to Rule 11. But has the petitioner complied with the requirements in that limited respect? It is clear that no notice of the nature of the proposed security was served on the applicant, the first respondent, by the petitioner as required by Rule 11.
So can you hold on?
Communication. Okay,
Lamin,
let me go.
can I ask
the
a
paragraph
question?
is not finished.
Let him finish. Let him finish, please.
No, but this is an important junction where you should stop. We evaluate that and you move on. Because remember, your audiences are not lawyers like us.
Okay. Me too.
So
I want to take you, Lamin, because I'm not going to allow you to get away with it. I'm going to systematically and strategically attack you based on what you're reading. Now you just read the last sentence for me. Just the last sentence.
So it says, sentence says, but has the petitioner complied with the requirement in that limited respect?
That's a question of fact that the judges of the Supreme Court are asking.
I know that, and I conceded to that at the beginning.
Now proceed to give the answer following that question.
So my first take on this matter, the first thing I said, the first line was, yes, I understand Rule 11 and its components, but that's the but. So let me continue. Let me continue. So it says here, it is clear that no notice of the nature of the proposed security was served on the applicant, the first respondent they're referring to.
Stop. Lamin,
stop. Let me finish that sentence.
No. Lamin, wait. Hang on. Yeah. If not, I'll just leave you to go. Just hang on. Let's do this nicely for everybody to understand.
Yeah.
Okay. Now stop. What you have just done now, based on the judgment that you have before you, is to read a question of fact that was raised by the justices of the Supreme Court.
I have a question.
The question is, was their service done? And then you went on to answer the question, which the judges again answered. Now, Sarjo made mention that the judges can make error. That is a subject of another discussion and another day.
And that's the error I'm talking about now.
Yeah, exactly. So now we are relying on the answer. And the answer is there has been no service.
Okay. That's what the first respondent's lawyer said. That's their paragraph there, not the court yet. We haven't got to the court verdict yet.
Okay, go on.
All right. Okay. So I am the UDP lawyer here, and you're the NPP lawyer here.
No, I'm not telling you. I'm just doing analysis on both sides. Okay, go ahead.
All right. So now,
who is Sarjo, the judge?
Yeah.
Who is Sarjo, the judge?
Yeah. So the paragraph continues. The communication relied upon in this respect by the petitioner, that's UDP, is the letter of 20th December 2021 from the Master and Registrar, addressed to the Registrar of the Supreme Court, confirming deposit of the sum of $300,000 by the petitioner as security for costs. The letter is only copied to C.E. Mene, one of the learned counsel for the applicant respondent. It is attached to the affidavit in support deposed by Maimuna Dibacham on 21st December 2021. This does not comply with what is required by Rule 11, which is notice of the nature of the proposed security to be served by the petitioner on the applicant, first respondent, and attached to a notice of presentation and a petition itself with the petition. Informing a third party of the deposit of security for cost and merely copying counsel for the applicant, respondent does not constitute compliance with Rule 11.
So can you underline that? Can you underline that?
Yeah, so look, from the beginning, I did say, if we go strictly with Rule 11, UDP lawyers didn't comply with it. I said that from the beginning. What I'm saying is, on this particular point, just because of that tiny little bit of it, yes, on technicality, it's wrong. They didn't comply. But what I'm saying is, because this matter came, they've complied with a lot of other issues, except that particular thing that should have gone to the first respondent, that's Barrow. Nature of that security of cost and security of costs. Courts usually adjourn matters based on simple things like that and say, okay, Barrow hasn't got 5 days to go through this, so he can respond to it. Can we convene again? Instead of striking it out on the 28th of December,
Mm-hmm.
can we, or 24th, was it 24th?
28 Tuesday.
28, can we give Barrow 5 days from the 28th to be able to respond to this? That's what I'm saying, for the benefit, because sometimes some of these rulings, whether you know it or not, they might not write it. It's unwritten rules. Some cases are decided in a certain way based on public interest. Public interest issues do have a heavy weight on cases. In my view, yes, I said from the beginning, that was my first sentence, that yes, Barrow didn't, the first respondent didn't receive the nature of cost and the cost itself. But on this occasion, it would have been beautiful if the Supreme Court adjourned the case so Barrow can have 5 days to deal with this nature of security. But again, I've said this, and the first thing I said was, yes, I agree. If we have to go strictly by it, yes, the UDP lawyers didn't comply.
But that's not what you said initially. Initially, you said initially what you said was that service was done. Now you're saying that they didn't comply.
No, on the third party, yes.
But also someone told me. Yeah, but also someone told me if this was dismissed because of Rule 11 within the 5 days frame, therefore the Supreme Court should also comply with Rule 10.
Yeah.
I don't know what is Rule 10. Can you guys help us with that?
I don't have the rules.
I think, yes. Rule 10 is the IEC should at least notify and then have this thing gazetted. But I think the court let that be. What essentially Rule 10 is requiring, once there's a security is affixed or petition is being challenged, IEC should at least notify all parties and then also have the petition gazetted to let public know that this election has been challenged as a form of a notice. You understand? I think court is dispensing with that. No one challenge it. But I think what Lamin is saying, the first two sentences in that paragraph he's reading, those are questions raised. They are not finding of facts. And then the court, make a proposition that this is what the first party argues. But I think the distinction in that paragraph is the court acknowledged, like the email, the letter dated 28 from the master was at the master's own initiative, but not by direction from UDP. I think that's where the distinction is. Hadn't been UDP actually instruct the master to do so, you can, because if you say petitioner must serve, it doesn't mean petitioner has to get up in person and then serve the other person. They can have someone else do it, just like the register does. So I think the distinction here is the master, sua sponte, is just informing the court what just happened without, instruction from UDP lawyers. That's my understanding there. But Tamba, what you are saying, I understand. Forget about the case, because Tamba is not questioning the fairness of the ruling. What he is saying basically is,
what I said at the beginning.
In law, you call it substantial compliance argument. UDP could argue we have substantially complied with Rule 11, and then as such, the public interest required this case to proceed. The answer to that is these arguments have been raised by other lawyers in other jurisdictions. I know UDP has not raised substantial compliance, but this argument have been raised, in Sierra Leone, a case that has been cited by Supreme Court in their judgment. It has been raised in Zimbabwe, in the UK, and then in Malaysia, in Canada. Those arguments has been made. In essence, Lamin is saying the court should be able to, because of the importance of this litigation and then the public interest in it, should carve the rules out and then extend. That's judicial fiat. You cannot do that without having the authority to do so. Courts have general powers, but even as India, UK and other courts have stated, election petitions are not, suits in common law or even in equity. They are purely statutory. So you have to look at what the legislature asks you to do and then act within that ambit. So in these instances, in as much as even me as a jurist, I want the court to actually extend time, but they don't have the power to do so. The court has the power to make the rule. The Election Petition Act says Chief Justice and then the rule makers could make rule regarding election petition, meaning they are acting under delegated authority. And then they came up with this election petition rule. That's on them. Now, the distinction here, what Lamin is saying, the same thing happened in Sierra Leone. I know the Supreme Court has not cited that, But in Sierra Leone, their argument was, wait a minute, the Election Act says there should be security for cost, and then the court should put that security. Court, you have failed in your power as part of the rules to tell us what the cost would be. You could have determined the cost, initially, and says any election petition you must file $100,000 as cost. You haven't done that. How can we serve something that we don't know, since we have to apply to you? And then in that case, Sierra Leone actually, covered an exception. They accepted blame, in that decision. They were like, yes, the court is at fault. We agree that substantial compliance in that argument would, fair. The problem was there was lapses in the decision. When the court actually tell them you could pay this amount and then pay it within this time, they never did. They sit on their right. So, but even if Lamin's argument, you want to give that to UDP, in UDP's case, UDP filed a petition on the 14th. The very day on the 14th, they also file another notice, as part telling the court, we want you to fix security. On the 16th, the court issued a ruling saying that pay 300,000. And then on the rule 11, you don't actually have to pay to notify the respondent. All they have to do was to let the respondent know, oh, by the way, court has set the cost. It should be 300,000 in cash. That's all you have to do with a notice. And then it's going to be difficult to argue substantial compliance in this case. And then those arguments have been made by other petitioners in other cases, and then they all fail consistently. The ruling itself, you might say, our Supreme Court only relied on, 1800 judgment like William V., Mayor of Tenby, and then, the Shrewsbury petition in 1868, back in the days, and then the Malaysia case in 1967. But there are subsequent ruling after this, and then most important, the one in ULA, UK, and then Wales, Court of Appeal. That was in 2002, and then there's a case out of Uganda in 2008, Zimbabwe 2007. So there is a lot of jurisprudence on this very issue, and the rules, they are just like we all copy and paste from England. The distinction, the only place where I see courts actually allow, petitions to continue without striking them out, the legislature actually give court the power to extend the time in rule. That's the only distinction. And then that was the case in Uganda. Uganda, they have the same rule just like Gambia, and they importantly covered. But most importantly, in our own jurisprudence, Supreme Court decided to save the case.
Yeah.
And then that case actually stated that we do not have the power to extend time. And then we are going to require strict compliance with the election rules. So at least everyone should be on notice that there is precedent for this. So I think in as much as we can falter the court what they can or cannot do, in my opinion, they don't have the judicial fiat to do that, because there is no rule that asks them to do it. So they can't. It's just legislative change it. So we cannot input that on them. That should be on the litigators themselves.
Sarjo, somebody asked, Sun to Defense asked, he said, what is the objective of Rule 11? Ask Sarjo.
The objective, I think, two things, in my opinion. There's a public policy reason. One, you want the respondent to know that you have been sued, and then this is the security of the cost. Just they don't want surprises, fairness. That's the objective. You understand? But most importantly, too, Rule 11 require nature of security. And if you looked at the election petition rule, court could order security, or sometimes you could ask for your own recognizance, meaning you would put surety instead of paying a fee, saying that, hey, I don't have the money, but I'm going to make a promise, like a promissory note, and then, I'm going to put up sureties. The issue with Rule 11 is, in case if there is no monetary amount, given, but you opted for sureties, if you notify respondent, they too have 5 days to object to see whether sufficiency of that surety is there, because they too have that right. The exception is if you are paying cash, respondent could not object to that, whatever amount the court says. But if the court only asks you to put a recognizance and then asks you to provide sureties, respondents have, they have also, right under the rule to object within 5 days. That's the objective, I would say. And then the problem is, I understand people go, oh, this is the policy objective of the law. So since, like Lamin's argument, you have the petition, the master send the email, everyone know what amount was paid, there's no prejudice here. We would all agree there's no prejudice to the respondent. They know how much was paid. They have the petition. So no foul, no harm. We proceed. I would understand Sunto's argument from that end. But the problem is, if legislators are making, laws, we have to at least understand their intent. They are aware of this. They could have simply said, you may, or they could have actually said that, you know what, you could send this document one at a time. They decided to ask and then put that burden on the petitioner to send all these documents at once at a specific time. So there's a reason
Within
for
a
doing it.
specific period.
So you
Yeah.
cannot falter the court for
No.
what our lawmakers do.
Absolutely.
In as much as the objective might not sometime, reason with the strict compliance of the rule. That's not for the courts to do. So that's on the legislature. And then we cannot extend or make my problem with this, because I review this thing and then I listen to a lot of commentaries. You cannot falter, like as what happened in Gambia is an aberration. We may not like it. We might even question whether it actually, serve the public interest in this case. But that's the lawmaker's job. Let them go and do that. What
Okay.
happened in Gambia has been happening consistently, and then the jurisprudence, like I said, is in the majority. It's not even in the minority. And then it's not like it's 1800, 1900. In 2000s, decisions like this have been happening.
And,
If people do their research.
Yeah, and the inconsistency as well, like you said, with the costs involved, they're not specified anywhere in any of our
That's the court's
legislation.
fault.
So
Yes.
the court made that up as to this is why. So why can't the court do the same to ensure there's consistency all through the case? You understand? I don't want to think there is bias in this issue. I don't want to think the court should set rules. The laws are there for a reason. We must follow them. So this is why I'm not saying that the Supreme Court was totally wrong to strike out the petition. To be honest with you, I don't even know, apart from making orders for fresh elections or in totality or in some regions, I don't know what other remedies are there in terms of election petitions in the Gambia. All right. So for the court to strike it out, along the way, they accepted to set some standards, to set costs. So when it comes to something as technical as that, Barrow didn't receive it with the nature of security and cost. The court could have just, look, these things, yes, Rule 11 says that. I don't know. I don't want the court to be making the rules as they go along. The legislature does that. I admit that the court's job is limited to what laws they have before them. And I made that clear from the beginning that I don't want to question the fairness, because that will be wrong. Yeah. The rule says black and white. You didn't do black and white, fine. But between that black and white, if you accepted red somewhere, when it gets to yellow in between somewhere, and that red that you accepted initially favored one person, if yellow comes somewhere, you need to accept that it fits within reason.
But what was the red that was accepted that favored one party?
Well, if they put security there, what if UDP said
how did okay, I'm getting confused.
Let's suppose it's GDC. Let's suppose it's GDC here.
Yes.
Right? And we said no, the Constitution or the Elections Act or something didn't say 300,000 or 100,000. We can only afford 5,000 because the Constitution didn't say that.
But wait, I'm confused here. You guys are confusing me. Who said it was the court that stipulated the amount of 300,000? Who said that?
No, but why? What would? So,
but how did it come up? That 300,000.
I have to admit.
Did you listen to what Sarjo just said?
No. I just said something.
Yeah. So you are assuming, Lamin, that it was the court that stipulated the amount of 3,000. That is not correct.
Yeah, let's suppose UDP stipulated it, or NPP stipulated it, or whoever stipulated it, but it's not in our laws right now.
That's a misstatement. Like, this is how it is. It's important. We can disagree with analysis, but the law is very clear.
You have to get the law right.
So how did they arrive at that
300? Yes, that was about to be my question.
Degree 98.
Yeah.
The Election Act says that whenever election petition is filed, court must set security. The Election Act says that there must be security, but Election Act did not specify the amount. You understand? And but the Election Act gave enabling rules to the rule makers to set up those amount, which is the election petition rule. In the election petition rule, if you looked at Rule 6, It doesn't say petitioner have, it doesn't put the obligation on the petitioner to ask the court to motion them to give. The court supposed to say that, but court did not. What UDP did is good lawyering. They proactively motioned the court to say, hey, the law says if we file election petition, security costs must be paid.
Absolutely.
You are responsible for setting that cost. You understand? And then we want you to affix the cost. And then Chief Justice came and say 300,000 as part of the is it on the 16th, December 16 order, the Espade order says pay 300,000. UDP has an option. If they cannot pay the 300,000, the rule is very clear. You could opt for sureties and say, hey, look, we don't have this money, we'll pay this thing. But respondents could object. But the court actually has the power to set the rule. My beef is the Election Act and then the rule, the court should have at least say what the amount would be. They could put 500,000, 300,000, whatever it is, right? They can put those numbers there. That way, if you're filing your petition, you either pay with it and then do service at one. That way, you don't have to falter. Or in this case, like what happened in Sierra Leone, where they should put the amount, they never did. Petitioner filed the case, and then when they petitioned the court for the amount, and then by the time they know how much they should pay, it was outside the 10 days period, court actually gave them substantial compliance with the rule because the court did not say how much they should pay. In UDP's case, as of on the 16th, they know how much they should pay. The rule doesn't say you must pay before you send notice. All you have to let the other party know
is the intention of
the nature of the security.
The nature
is
I
cash.
know.
That's all.
Yeah.
You understand?
Yeah.
Now, saying how much the amount is, court has the power to argue. Now, that's in law. You could argue, hey, in as much as the statute says you should fix the cost, let's say the court says you should pay 2 million. You could argue that somehow put an undue burden on the petitioner in exercising their constitutional right, and then you could challenge that. That's a different story. UDP is not contending or complaining about the amount. So we have to assume they can actually afford that. So that's not the issue here. But the court has the power to set that amount. So, my beef is the court should do so to avoid, because 5 days is very short. And then what this ruling has not said, this is what we have to understand. In as much as, this case actually struck at the petition, a lot has not been answered because the case never go forward. For instance, is the president still a proper respondent in election petition? Remember, respondent withdraw their motion, the first motion under Rule 69. Maybe they figure they are going to lose, but that question has not been answered precisely by the Supreme Court, whether you could still sue the president even in election petition. Contemporary jurisprudence would say yes, even in Ghana, where we copy and paste their constitution. But there, under the constitution, under, I think, Section 88, they actually substitute the president for the attorney general. Gambia doesn't have the same section, but that question is still lingering over there. 2, in as much as UDP proactively asks the court how much they should pay, the rule never put that burden on them to ask. But it would appear in this judgment, the court foist that obligation on the petitioner. Is that how we should proceed? We don't know.
No.
3, hadn't been UDP when they filed that motion to ask for cost. Let's say before the court get back to them, it takes 4 or 5 days and it's outside the 5 days period, right? And then now court tell them you are to pay $10. Would the court agree with substantial compliance? We don't know. And then future attorneys would not know how to advise the guy. So there's a lot of unknown because this ruling was prematurely killed. I know that. And then we all cry for that. But we cannot say the judgment, in as much as it might be draconian, my argument is there is no power, even under the Supreme Court Act, like other jurisdiction. If you want to critique the ruling, you have to look at, similar cases.
Yeah.
Under Supreme Court Act, the general powers of the court, you could say, the Constitution says you are responsible for the administration of your justice, meaning inherent in it, you could make rules that is convenient for procedures. But even rules, there are hierarchies. And in this instance, the election petition rule has a hierarchy and it has precedent over the general rules of the Supreme Court original jurisdiction. And then unless there is some kind of, a lacuna or gap in that election petition rule, the court might exercise other powers. But where it is expressively clear, you cannot go contrary to that. That's what the issue is here. And then that's what people should understand. I think our focus should be on the National Assembly to change things, but not with this judgment.
Mel.
Yes, ma'am.
Mel, the debate is about, was it in fact procedural or technical failure that caused the UDP? Some are saying it's technical, some are saying procedural. We just need the clarification on that.
I think it depends. It depends on what's your definition of procedural and technical. For me, the procedural nature of it is the technicality of it. There's no distinction between procedure and technicality. It's just that the fact remains that procedure is part and parcel of the dispensation of justice. That is why if it was a criminal case, you will have the criminal procedure governing the regime of whatever happens. If it was a civil case, you will have the civil procedure regime. And of course, the courts have given their own verdict to say that this is neither civil nor criminal. It's on its own. You know, I'm not good with pronunciation of Latin, so Lamin or Sarjo can help me. It's sui generis. Is it sui generis? Sui or sui generis? Sui generis. Okay. So the fact is, and I think we should actually go into the substantive reasoning of the discussion, because we were so stuck on this bit about the rules. But the fact is, remains, and this was what I was trying to get across to Lamin, and I'm glad we're now on a equal page and equal footing, that what the judges have said, that they don't have the power to make the rules. They don't have the power to extend the time. They don't have it. You know, they cannot use their own discretion. In this instant, they were very constrained to keep to the rules, the strict adherence of the rules, because of the nature of the matter. You see, election petitions are not just like any other matter. These are high interest litigation. They're high interest matter that you cannot even circumvent or begin to do things that are not applicable. And like Sarjo pointed out, and which I think initially, people were saying that, we don't have much authorities, case law. That is not factually so, because we have a whole lot. And most of them are not like 1962 or 1967. These are recent cases. You understand, as far back as 2000. And the way and thinking and manner of the jurisprudence in our jurisdiction is that when it comes to such nature, a strict applicability of the rules and procedures are what is done. So I think really, going back to answer your question, there is no distinction between procedure and technicality. The two are the same.
Okay.
Technicality might, that's a procedure. So in that procedure, there might be one technical point. So maybe technicality is just a component of the whole procedure.
Okay. So Tamba, are you saying this wasn't sufficient enough to throw out this case?
No, I don't like it at all. That is not to say that the Supreme Court didn't apply the law strictly. And I made that at the beginning. I'm not just happy with the fact that just the nature of security not going to the lawyer or the registrar. The registrar had it, but it didn't go to the first respondent. Just minor stuff like that. I'm not just happy. But again, I made it since last week. I did say we did a good review of our laws, make it crystal clear, go in detail, make sure they're consistent. You understand? When I get an election petition at the Supreme Court, I should be able to know ABC straight away without having to debate what the Elections Act said and what the Constitution might say and what the Supreme Court Act says. They should be in line. So again, this is why we need to review some of the things we do. It'll make life easy for people. This is a major case. We have a huge challenge. We had a huge challenge here. And just because the nature of security didn't get to the first respondent, but the court had it, or the lawyer had it. They didn't give the lawyer the full nature of the security and cost. Even if they did, the court is saying that it should have been the petitioner, UDP themselves, should have served on Barrow.
Yes.
You understand? For something like that, I believe we would have had a case here if we went to full trial. But I'm not going to say the Supreme Court was biased in applying the rules strictly. I agree with that 100%. So I'm not gonna knock.
Mel, go ahead.
Lamin. Yeah. Just it's as if the Supreme Court justices were actually knowing your line of argument. I know you had said that they complied with everything except this one particular issue, and I'll go into the judgment, and this is what they had to say.
Yeah.
It says the same principle applies in all elections in this jurisdiction. The obligations set out in Rule 11 are cumulative.
Yeah.
They are not disjunctive. That means each single obligation must be adhered to. A failure of compliance with any of them will be lethal and fatal. So basically, it's exactly addressing what you're raising. It is saying, if you comply with one and leave the other, comply with two and leave one, comply with one and leave two, what it's saying is it is cumulative. It is not disjunctive. And therefore, if you do not comply with any, it is absolutely fatal. And that is the law. And the Supreme Court justices had set the standard that when it comes to petitions, they would apply the law strictly.
Yeah, but if you look at the Supreme Court Act, correct me if I'm wrong, Sarjo, the Supreme Court Act itself, I think it's a section somewhere around the 60 or 61 or 62.
62 most likely for election.
Yeah, it just states when the petitioner serves on the registrar, then the rest of the service will probably go from the registrar to the respondents. I'm not conversant with the Supreme Court Act. I haven't got it. I will look into those matters. Again, these ones needs to be brought in line with the Elections Act. The Constitution itself doesn't have to be touched because the Constitution gives you the framework, the skeleton. The beef is the subsidiary legislation or secondary legislation, whatever name you call it. So again, if, for instance, a petition is gone to the registrar and they're happy with UDP submission and it fulfills with all, I believe in this case, the Supreme Court should have served on all the respondents. Then we'll not have all this back and forth. The registrar has to do it, and then the petitioner has to do it again. But then again, the rules are what the Supreme Court has to deal with today, not what is going to happen in the future. So we need to look at these rules again. And there's so many things that happen in this petition that I'll talk about again in the long run, but not on this particular Rule 11. The Rule 11 was not complied with, and I'll agree. If there's struck that petition out based on that, I cannot question it in terms of law. The facts are what they are. You understand? But politically, there's lots of other things that happen, and legally too. Again, Melville and I had a back and forth on this, but I think I'll chop his head off when it comes to conflict of interest. We'll get there in a minute.
Gambia.
I'm not delving into that because as far as I'm concerned,
I will
take my break.
When
you come to that issue, then I'll take my break because I'll leave you.
You like SFL, he ran away when Ali Bensouda was coming to TRRC.
Sarjo, where do you think UDP lawyers boo-booed? How did they miss this?
I mean, it happens to everyone in practice. You are not. I cannot speak for them.
Yes,
and then
you cannot speak for
them. Both election petitions are not easy, and then you need a team of lawyers. Even here, small matters, the benefit of the doubt, you have team of lawyers, and then somehow delegate authorities. You would have one team of lawyer who is assigned with reviewing procedures just to make sure you have everything top notch. One would be reviewing prior case laws. The other ones are contemplating any kind of criminally challenge or objections that they could do. So speaking from a lawyer's point of view, the petition itself, the substantive petition, they did excellent job in that. It's just somehow it could be many factors. Maybe they are emotionally connected to the case, and then somehow have foresight, forget some things. But what is clear, just reviewing the ruling, and then I wasn't aware of this. I don't even know there was precedent in Gambia in the bus case where the same thing, the court refused, and then that was Rule 15, and then the court is saying Rule 11 is, almost substantially similar to Rule 15, indicating that we visited this issue before, and then we have not changed. So if you're a lawyer coming to court, and then you want to argue that some rule has to change, is bad law, you want the court to depart from that, at least the court has to have the power to do that. You could do that through judicial opinion. But here, even if you ask the Supreme Court to depart from prior ruling, they don't have the power. It's just like if National Assembly could actually overturn constitutional precedent that Supreme Court did. That would be nuts. You only do that through constitutional amendment, or the court actually change those precedent on their own sitting. But National Assembly don't have the power to alter judicial decision. They can overrule statutes where court interpreted if they are not happy with it, just like the rule here. But constitutional decision they can't. The same way comes to legislation. That's within the ambit of National Assembly. They make those laws. The court interpret them. The problem here is National Assembly actually foist this provision on the court. They are saying, Chief Justice and then the rule makers, we want you to make rule for election petition. These election petition rules predate 94. We just copy and paste from somewhere and then leave it over there, which in fact lead to the fact that we have a fault not putting out the amount or any of these things. We never thought we are going to visit it. No one actually reviews our law. That's the problem. Notwithstanding, there is no distinction between, if you looked at Rule 62, even the Supreme Court Act itself, which came way later, the election petition rule. Rule 62 only says what the petition must look like in election petition, but it actually require you, except as otherwise stated in the rules of election petition, which is the rule itself, where Rule 11 is part of. That's what they rely on. I think this is a good opportunity for Gambia, the lawmakers. Well, National Assembly is not doing this because Supreme Court should make this rule. They give them that, authority to do. But our legislature could take that, authority back and then rewrite a new election petition rule. What happened in UK after Shrewsbury in 1868, and then the William V. Tansby, mayor of Tenby, that our court cited to. UK itself changed their rule. Now they gave the court the power to enlarge the time, right?
Yeah.
To make
and they did that with prorogue in Parliament as well.
Yeah, and then they do, because they were like, look, this is how we do things back in the days. But this is unconscionable. We are going to give this power to the court to extend time, but they must do so judiciously, meaning you cannot extend time for everybody when there is compelling circumstances. And then Uganda too, which copy and paste exactly like UK, and then even the rules are numbered the same way, they also extend that time. And in a decision in 2008, Uganda Supreme Court revisited an election petition, and then the trial judge, the High Court judge, says he refused to extend time, saying that I don't have the power. Uganda Supreme Court reversed. We're like, wait a minute, you do. Section 19 of our law says judges have the power to extend time. And then the problem with Uganda too is, just like Gambia, it says you must post security. It never say the amount. That was on the court. The court accepted their fault and then gave them 7 days to go and then pay that and then amend their time. My point is, Gambia too, if we want, we can empower the Supreme Court to extend the time in election petition, but we tell them anyone who wants to request extension of time, they must show clear and convincing evidence that, they are not doing dilatory tactics, or they have to do some kind of, put a higher burden before you allow that extension. Because if you willy-nilly grant exception, it somehow subsede the entire rule itself. No one would have to comply with time anymore. You would just come and say, I want extension. So those are the issues that, we are seeing. But at least this is an opportunity for our lawmakers to learn from and then review all these election rules that somehow predate our constitution itself to at least come up with things that are in line with, common sense and then modern time. That's, a valid argument, but this one is not on the cards.
Tamba, is this the end road for UDP's petition? Do you think?
As far as I understand,
ECOWAS,
I don't think ECOWAS has got the mandate to get involved in election petition disputes. ECOWAS will probably step in where there is a threat to a nation's peace or human rights violations or matters like that. I think constitutionally, as far as election petitions are concerned, this is the end of the road.
Except if they can fundamentally prove to the ECOWAS court that the ruling of the Supreme Court amounts to some fundamental human rights violations of a large number of Gambians by denying them their vote. I don't know how they're going to do it, but that's the only way I can say it.
I doubt they're going to have any.
But I don't think that will ever.
I don't think they'll succeed in doing that. But again, there are issues that we should question with this election petition, and I've made those clear. Not with the Rule 11. No, I'm done with that because
yeah, but just go in. Let's look at that. Yeah. Let's
so
look at few of those.
Yeah,
because it's a learning process for us here.
Yeah, we have a case here, and always with Gambians, and I keep telling them this: always flag up stuff at the from the onset. Do not wait until you get a negative result, and then you start complaining about the process. But you've been there watching the process in person. So people. Basically, Melville is gone. We have got the Chief Justice of the Chief Justice of the Republic of the Gambia. All right. The parties in this election petition are three: Barrow, the IEC, and the Attorney General. In those, among those three parties, one of them, the IEC, was represented by the Chief Justice's son. Now. In the United Kingdom, that would never happen. It will never, ever, ever happen. The remotest of links you have between a judge and one of the parties to the case, the remotest of links you have, that judge will have to recuse themselves. That's what happens over here. To have a Chief Justice, yes, it's a panel of 5 judges, all right? And one of the representatives of one of the parties, which is the IEC, you have Keba Sanyang and lawyer Malik Jallo representing the IEC. Malik Jallo is said to be the biological son of the Chief Justice. Let's suppose this election petition was tied. The justices were split 2 ways, in the middle, right in the middle. 2 saying, no, we don't think that security of cost alone not going to the first respondent was enough to strike out the petition. And the other 2 says that's enough to strike it out. The Chief Justice has to vote one way. If he voted in favor of the IEC and Barrow, what do you think people were going to say? He voted in favor of his son. Do you understand? This is what the law tries to cater when it comes to conflict of interest in terms of judges. They've got their own set of rules for judges. You have to declare. As soon as a name pops up and you know the identity of this person, if they're your neighbor, your ex-girlfriend, your ex-wife, your wife, your good friend, or somebody you've had beef with, an enemy, and is known, well known openly, or it's a company that you've sponsored before, you sat on their board, something like that, anything to link you on a personal or professional capacity, the judge should just leave the case. Because what would happen if the son left the IEC, then somebody comes and replaces it, he'll still have that element of judge being biased. It doesn't mean the judge will be biased. He'll have that element of bias. The judge will say, okay, well, my son was part of the IEC. He only left because I'm the judge here. You understand? So things like that, if UDP flagged it from the beginning, I don't know why their lawyers didn't flag it up. You understand? It will not happen in the United States, because I read a lot of Indian law, case law, when I was doing my GDL, the substantive part of law. And when I was doing the legal practice at the University of Law, Moorgate in London, we read a lot of case law as well. You cannot have a judge sitting on a case where their son or their daughter or their neighbor or their friend or anything with a personal or professional links or pecuniary benefits. If I have shares in Gamtel, I cannot sit on a case where Gamtel is a party. It will not happen. Doesn't happen anywhere else. You understand? I'm not saying this is what happened in the Supreme Court. The rumor of the decision being split is a rumor. But let's suppose that's what happened, and the Chief Justice has to weigh in, because if there's a tie, the Chief Justice has to vote one way or the other. Could vote for the IEC, could vote for the UDP. But let's suppose he voted for the IEC. What happened? Or Barrow? What would people surmise from it?
Yes, let me ask.
It's deeply dangerous. It shouldn't happen.
Yes, Sarjo.
The same thing they do with the Jana Commission, Surata Jana and Amil Bensouda. The same thing they did with the TRRC. Lots of conflicted individuals investigating or sitting on cases against somebody they don't like or somebody they're related with. It should not happen. That should not happen, and it must stop.
Yeah. Sarjo, I went for jury selection before anything. They say before I will be sworn in, I have to, they ask me if I know the clerk, if I met this lawyer, the counsel before, if I know the I mean the questions after questions. What Lamin is saying about Gambia, is that the right thing?
Well,
Like how the same case, the son, the daughter, whatever, the mom,
let
everybody
me
will be,
speak of
yes.
the US
Mm-hmm.
and then Gambia, because I'm not privy to
Yeah, Melville will come to Gambia then. Yeah.
Code of Judicial
I, I,
Conduct.
I
And
did say I
you
did
know,
say I was not going to speak on this issue.
you know,
So
so I'm not
You can run.
because I don't know, what the Code
Mm-hmm.
of Judicial Conduct is in Gambia. I
Mm-hmm.
suspect they should have one, and then it should have conflict of interest should be in it.
Mm-hmm.
And then if not, I'm not sure what the practice is. I know the Legal Practitioner Act deals with lawyers, so I'm a little bit familiar with that. But in the US, canon of judicial conduct, like what Tamba said, that's absolutely correct. Here, for instance, like people, like judges' sons, your daughters, or even individual in your household, if they're a party, you will recuse. It's not just the appearance of fairness, but the impropriety itself. That's what the rule is questioning. Or even if you make a comment on a case that's pending, we have judges being disciplined for that here. You will recuse yourself. We have seen judges here in the US that handle cases at Court of Appeal, and then they were elevated to our Supreme Court. When those cases come, you have to recuse. And then we've seen cases where Justice Marshall himself has to recuse himself. So
Yeah.
those things happen here, and then even in courtroom, what I expect, like here, if parties are related, judges would, let's say it's a distant relation or even close, but you think there will be no bias. Disclosure is required.
Yeah.
It's just like if you file an amici, you have that interest. You have to disclose that. A judge could come and then, let's say I'm sitting in a case and Tamba is my friend, but we are friends, and then we have no businesses together where money is involved, and a case is in front of me, and then somehow he's connected in it. A judge is required to disclose that to the party. Hey, by the way, party X, I know of party Y. Are you going to make a motion for me to request myself? I can assure you my friendship with him or anything. It's not going to impair my judgment here or sway me one way or the other, but I'm required to disclose it. Are you okay with that? If you said yes, it goes forward. If you said no, you can. A classic case is Pinochet, the Chilean dictator, where the House of Lords actually agreed to extradite him for violation of human rights when Young's case was happening. His lawyers petitioned for a review on then the fact that the Amnesty International lawyers, I think one of the parties there
One
was
of the
somehow
panel of judges. Yeah.
was associated, or the wife was working for those things, because they failed to disclose that. They squash and set the judgment aside, and then a fresh panel has to review the case just to make sure to remove the appearance of bias. I didn't know the relationship between, what Tamba said with the Jallo and then the Chief Justice. But my thinking is, if they are father and son, at the very minimum, I would expect them to. I think all the parties would know
Somebody's
that.
down there. He's running away from it, but
No, I mean, like, these are issues
yes,
we'll talk
we should.
about, and then it doesn't mean it's distracting. But I'm just saying, from a legal point of view, I would expect the judge to at least flag that himself, like, hey, wait a minute, councils. I don't know what the rules are in Gambia. Maybe the Gambia, the rules are you just disclose. If any of the party want to make a motion to recuse you, you do. But at the very minimum, I would expect that, in chambers, when there is a conference, like, hey, guys, I'm related to this person. Did any party have any concern or issue with that? If the rules in Gambia do not require mandatory recusal, like how it is here, I would expect at the very minimum that disclosure will be made. And then if councils have the confidence in the judges to kind of like, oh no, we don't think that's going to impact you one way or the other. And then a clear point of view is IEC objected to their joinder in S party, and then Chief Justice rule against them. That reinforced, if there would be any supposed bias, he actually ruled against his,
Own son.
son, allegedly, in that situation, and then also says that service on them was timely. So at least in these instances, we want legitimacy in judicial decision and opinion, because remember, judges don't command armies, They don't have the pulse of the National Assembly. All they have is their word. If that lose legitimacy, it doesn't mean anything. But I understand Tamba's argument, and then that's the contemporary jurisprudence. But in this case in Gambia, I would expect if that's the relationship, there is at least a discussion about it with the parties in chambers.
Yeah. Mel?
Okay. Like I said, I told Lamin I didn't want to say anything about this because we've had considerable argument outside this program on this issue. But me, I look at things differently. Just because it's obtained in America or it's obtained in England does not necessarily mean that that is what is obtained in the Gambia, especially when we talk as lawyers. I mean, even authorities outside the jurisdiction of the Gambia are merely persuasive. They're not binding. Okay? So yes, the states in America, they have their own rules, they have their own code of conduct, and in England they have the same. But in Gambia, we have the code of ethics of or code of conduct of 2011, and then we have the Legal Practitioners Act, and none of these prescribe anything that frowns on Malik appearing before his father. So yes, like we all are discussing, there should be a look at the rules, and but until that happens, as we speak now, there is nothing really that is by way of regulations or anything that is laid down that actually bars him from doing that. And like they have rightly cited, he ruled against the IEC, who the son is actually acting for. I mean, even in the judgment, he deemed that they were adequately served, and so on and so forth. And we also, you see, like I tried to explain to Lamin, Gambia is a very small country. Okay. Yes, now we're having a whole lot of lawyers. Okay. But if you look at the history and the evolvement of the law, if you were to say that just because he was a lawyer because before his father was made a Chief Justice, he was practicing before his father was made a Chief Justice, okay? And to say that he cannot appear in any matter just because his father is sitting, especially in a panel, I could understand if his father was a lone judge. I could have understood that. I would have, to some extent, accept what you're saying, But a panel of eminent, justices that have been sitting for, they have about at least minimum 30 years under their belt. You understand? I mean, I don't see how it fundamentally affected this man. And remember, the IEC was not a party to the suit in the initial stages. Okay? And he is by virtue of his own retainership. So it's not that they just went and got him simply because he was being brought before his father. So I don't see any issues of
there are major issues here. I mean,
well, yes, I respect, and this is why I said I was not going to argue with you. I respect your position, but as a lawyer, and this is my bit with you. When it comes to this issue about the election petition, I mean, you are a stickler for the rules. I know you personally outside this discussion, and I know you're a stickler for the rules. You're a stickler for the law. But when it comes to this issue, you want to circumvent the rules, you want to circumvent the law, and you're talking about the lawyers using discretion to make rules, lawyers going outside the law and all that kind of stuff. And I know you personally. I know how much you stand for the law. You believe on the dictates of the law. And all I am saying is, yes, you are right. The observation is right. The observation is fair. But within our jurisdiction, within the regulations that govern the lives of lawyers, there is absolutely nothing that bars.
I want to make sure I understand this correctly, because I'm not familiar with Gambia. You guys know. So you are saying in the code of conduct, conflict of interest is not addressed at all? Like there is no conflict of interest? Because I know let's say even if the rules do not cater for that, Gambia in Yankuba's case, Supreme Court just says without. No, but Gambia is as part of our law is common law too, And then Supreme Court reiterated that in Young's case, saying that common laws of England are laws of the Gambia and it doesn't need domestication. That's clear in order to arrive at the decision they did at the Young's. If that is true, even under common law, at least conflict of interest is something that has to be disclosed anywhere under common law rights. But are we saying our rules itself says no issues, because it's not just about fairness, it's the appearance of fairness that matters in anything, in anything to have legitimacy. For me, my thinking is no public official in election should be doing their job, walking around, turning, thinking that, oh my God, they might remove me. That kind of cloud floated over your head. That's why the election petition rule put this timeline, and then they want things to be quickly resolved. Everybody moved on. And I understand that, as it happened in Yankuba's case. The other guy was there for so long, and then only to be yanked out. You are making rules you don't know. But equally, the same thing with our courts. Court's opinion, like I said, judges don't have army. The only way we respect their opinion, we respect the word. We see some kind of legitimacy. But I don't know, but it somehow would behoove me to think that we make rules, and then in that rules, we never even address conflict of interest. What if I have, if I'm the 60% shareholder in company X, and then a decision comes to Supreme Court, even though it's a panel, and then our rules doesn't even talk about this, much more even to disclose it? Is that the rule as it stands in Gambia right now?
No.
Can I answer? Can I answer?
Okay, go ahead. Yeah.
You see, even in America, the rules evolved over time. Even in England, the rules evolved over time.
Yeah.
And now what I am saying is, as far as I am concerned, Gambia was such a small jurisdiction that it is not uncommon to appear before a judge who might be your best friend, who might be your friend. Okay, you have to understand the historical context of our jurisprudence, of the nature of law in the Gambia. Now it's different, whereas in England, of course, like you mentioned, the whole issue about disclosure and everything. But in this matter, I don't think it is. I don't know how to put it, but I don't think it is not common.
No. I'm not questioning this matter. I just want to know, is it in the rules in the Gambia or not? Like Gambia right now, as it stands, are we saying the rule we have as it stands, like the code of conduct, doesn't even mention or talk about conflict of interest? That's what I want to know. I understand what you are saying.
I responded. I said issues of conflict of interest are there. Okay, I don't know specifically because I was trying to.
Oh, okay. So that's okay.
Yeah, I got up to actually look at the act, but I couldn't because I'm using my laptop. But I'm just saying, of course, there conflict of interest in. We've seen lots of examples in many cases in the courts, where lawyers have reclused themselves from matters. Of course, there is, but we're dealing with this specific issue where somebody is appearing before a judge. They're lawyers. Their father is a lawyer. We know, for example, Justice Sarjo. Justice Sarjo is married to a lawyer. Okay, now. You have lawyers who before they were appointed as judges or into the superior courts had matters they were handling that would eventually come before them. Okay, now what I'm saying is we had such a small jurisdiction that it's going to be very difficult. So should you say that any matter, his father is the CJ, so any matter that Malik is in, by virtue of his father being the CJ, so you're saying that there cannot be any matter where it would need the full sitting of the entire Supreme Court.
No, haven't there got any other high Supreme Court judge who can sit in for Hassan Jallow?
That's what I'm saying. In the instance that you need a full panel of the Supreme Court, what will happen?
They will have another judge. Haven't they got another judge who could make it 5 without Hassan Jallow?
From the Supreme Court?
Yes.
No, but I'm not sure you're getting my question.
No, look, it's a panel of 5. 5 judges, right? It's a panel of 5.
This was a panel of 5, but I think the full panel is 7 or something like that.
Yeah. So supposing they wanted 5 for this election petition.
Yes.
And Hassan Jallow is taken out of the equation by virtue of his son appearing before him.
Now remember, Lamin.
Yeah.
Hassan Jallow was already presiding over this matter before the IEC was added as a party to the suit.
So the son should not be part of it.
That's the moment. As soon as IEC was added to it, that's the moment he should have declared. And if the parties involved,
Lamin, as a lawyer, I am asking you based on what? On what rule are you relying on? On what? On what is obtained in England?
Okay, so now over here for practicing,
but we are not over here. We are over there. And
what conflict of interest is Melville?
No,
Melville.
but Lamin, I
conflict
am saying,
of interest is the same in almost the whole of the Commonwealth.
It is the same, but the interpretation of what amounts to conflict of interest cannot
your
be
son,
the same.
Your son is the biggest conflict you'll ever find. Nothing conflicts more than you sitting over your son's case.
Okay, Lamin.
If they said to me, if they said to me, there is a minimum of 5 judges at the Supreme Court, and there's no other judge apart from Hassan Jallo and the 4 others, then we have limitations here. All right. But if there's another Supreme Court judge who could have come in the minute IEC was added, and his son was
I mean, I wouldn't even go there. And I think you are right on this thing, the principle. I understand what Melville is saying. There's no rule. My point is, it's not about whether there would be bias, but the rules should be followed, right?
Yeah.
At the very minimum, even let's assume like the rules in Gambia doesn't allow recusal, like mandatory recusal if it's spouse or son or, let's say immediate family. And then by immediate family, let me qualify like parents, children, and then spouses, right? And then I'm the judge, and then I already started the case. A spouse, or a child, or my parent want to appear in front of me. At the very minimum, if I already started the case, that disclosure should be there.
Yeah.
And then if all respondent, if they want to sign a valid consent waiver to proceed, that's one thing. But my point is, at least like the Supreme Court says in UDP's petition, you have to comply with the rule. In this case, at the very minimum, even under common law, disclosure should be there. And then if the parties are confident in the proceeding, because you want to show the appearance of propriety in these instances, things can continue.
But
even if those mandatory rules are not there,
hold on, let me open the line for these guys because they have questions. Before.
I don't think you should just recuse anyone, but at least you should have at least go through disclosures, and then if disclosure is made, whether one should recuse themselves or not, you file motions here against judges. A judge could make a comment about, something that's very harsh, right? And then your client come in front of them, you ask the judge to recuse themselves. Judge would say, I'm not going to recuse myself. I know I said this thing, but it's okay. And then sometimes the appeals would actually allow that. But my point is the process. Disclosure is always required in conflict. Both parties should know.
Sarjo, I have a question for you. What is the purpose of having disclosures? I won't answer. I just ask you, what is the purpose of disclosure?
It's fairness. At least you want to show there's some kind of propriety in what is happening. Because even if you were fair, you want to show that there is no appearance of bias.
Exactly.
So that's the whole thing.
Exactly. So the whole purpose, substantively, the whole purpose of disclosure is to put the other party and to put all sides on notice of a particular issue that would arise or would amount to what somebody would, like you just mentioned, would come back and say amounted to conflict of interest. So when you do disclosure, is to put the other party who otherwise would not be on
and Lamin
notice.
is right in that. At the very minimum, disclosure is required.
Hang on. So you agree with me that's the purpose of disclosure?
Yeah,
do you agree with me?
Yeah, you have to put the party in notice to at least so that there is
I'm trying to build up my argument. You agree with me that the purpose of disclosure is to put the other party on notice of otherwise relationships or anything that would amount to conflict of interest that they would not ordinarily know or would be within their knowledge. Do you agree with me?
Yes, that's the general principle. Yeah,
that's the general principle. Now, in the Gambia, do you believe factually that there is any lawyer within the Gambia that is not aware, that does not know that Malik Jallo is the son of the Chief Justice?
I don't know. I cannot answer that.
Well, that's why I said I was surprised UDP lawyers didn't raise the matter. That's why I was surprised.
UDP, the petitioner UDP never raised the issue
they should
before
have.
the court.
They should have.
Exactly. So which means, and this is why I'm telling you, what obtained in the UK might be radically different from what is obtained in the Gambia, because the whole purpose of disclosure is to put on notice what they don't already know.
Yeah, but then
and the issue of Malik being the son of the Chief Justice, I'm sure the petitioners, everybody who's a lawyer in the Gambia, know that he is the son of the Chief Justice.
Yeah, but because
just because
UDP didn't raise it doesn't mean it's right.
If the petitioner in this instance decides to waive their right to raise an issue with regards to Lamin sitting and being being the lawyers of the IEC who are a party to this suit, I don't think this should be an argument right now.
No, it's not an
just
argument.
Because UDP didn't raise it doesn't mean it's right for a father to sit on a son's case.
But it does not matter. The petitioner did not raise it.
Well, okay, but I'm raising it so that these things might not happen again.
In fact, it was the petitioner that make an application to add the IEC as a party to the suit. And
that's
Melville,
the point.
I think you are correct in that, and no one is disputing that. When Lamin brought this thing in this context, that they are related. My point is, you could be very well right. I don't know. They're in Gambia. Maybe they know this thing, and then they couldn't care less about it because they know the character of the judges. These things are there.
Yeah,
that's needed there. My point is, in principle, just because there is a conflict of interest or there appears to be a conflict of interest doesn't necessarily translate that bias will happen.
Yeah.
Judges always disclose conflict, just like litigants, and then whether they should recuse themselves depend on whether there would be actual bias. That's the standard. You can disclose and still continue to sit. I may know Binter and disclose that, and I say, I'm not going to recuse myself. I don't think it's going to, affect it. But that's something, at least, if someone raised it, it would be preserved in terms of appeal process. But in this case,
and this is exactly what happened. Just because it's 5 judges doesn't mean the dad will not be biased. In Pinochet's case too, it was a panel of 5 judges. Just because one was related to Amnesty International, who was a party to the suit, that Pinochet, the petition from Pinochet's lawyers was upheld. But
because Lamin, in that matter, the facts initially was not known to them.
Yes.
Was not known to them. And like Lamin said,
so if we go on, if we raise a petition now against the Supreme Court ruling, do you think we might be able to hear the petition again?
They will flip it out. They will kick it out, man. Because what are you talking about, Lamin? Everybody knows.
I'm saying after.
This is what I want to know in Gambia. Because I'm thinking about this thing. Maybe Lamin and Melville knows it. This is what I want to know. Because I know it was not raised, in the argument. Because my thinking is, even assuming, in my case, I believe that service was not sufficient. But like, if this were to happen in the US, what Barrow's lawyers did, because this was their third motion, and then according to the facts in the ruling, the third motion was filed on the 21st. If this were here, any lawyer worth their salt would have moved and then argued that Barrow actually, he actually waived the right to personal jurisdiction. Because here, except for subject matter jurisdiction, where you could actually, argue that at any time court could raise it, if you are going to object to either improper service or personal jurisdiction, and then there is a responsive pleading required, even in our civil procedure, you must raise it at the first instance or lose it. It is true the court acknowledged that Barrow's lawyers entered a conditional appearance when they first came in on the 16th. But that conditional appearance, you raise it to say, hey, we have issue with PJ here, personal jurisdiction, and then we are raising it. And then they raised that under Section 69. They withdrew that motion, filed a second motion, still did not raise Rule 11. They have a second opportunity. At the third opportunity, the third motion is when they file it. So the question become, why isn't that, argument was raised that they have lost it? Because that's not subject matter jurisdiction. At that point, they have raised that, lost to raise the argument of, wait a minute, improper service. Because here, under our rule, you must raise it at the first responsive pleading, or if a responsive pleading is required, you must raise that first, or you lose it. It's a use or lose it kind of situation. Gambia, the civil procedure rule doesn't even talk about this. Let me put the Court Act, which is govern the High Court. But is there any precedent or what the rules are? Those of you, if you actually practice in court in Gambia, is that thing there, like where other than subject matter jurisdiction, PJs, you must raise it at the first instance or lose it. And then if so, why wasn't it raised at this particular case? Because I think that would be a better argument than saying that the rule conflict with the Constitution.
Okay, gentlemen, y'all hang on. Let me take few calls because they have legal questions for y'all. Yeah. Before we wrap up, we appreciate y'all. Hey, you can look below your screen. Our number is there. It's +167 839 Mr. Tamba. You can call. Mel?
No, I was just saying hi to my brother, Mr. Tamba.
Oh, okay. He cracked me up. He said, do they have a chance to go back to the courts again with their petition? Anyway, callers, you can call. Ask your legal questions, please. Hello, caller. Hello.
Binto?
You can speak any language. Yes. Bismillah.
Okay, Binto, this is Famara Singate. I'm calling from the Netherlands.
Oh, Singate,
yeah, Baraka Bake, la programme diata, la Panelist for Nambi Contona. Sarjo is a colleague. We are all lawyers as well, and Melville as well, and Mr. Tamba. They are doing a fantastic job. I really appreciate what they're doing, and I will encourage them to be doing this.
Hold on.
Mistake tanga find and we'll talk about
that later. Yeah, but I think you might get a lot of people online, so I want to make it short. But I really am impressive. I'm content about the Panelist. They really did very well.
Okay.
I just want to ask a question. I don't know because I don't have chance to read the ruling.
Go ahead.
Yeah, but obviously we as lawyers, we know the current conventional wisdom is that non-compliance with mandatory provisions of an act is fatal, as the Supreme Court held in this particular ruling, the issue of fatality. But as I said, the current conventional wisdom is that non-compliance with a mandatory provision of an act, not a rule, but of an act, is fatal. But whereas a non-compliance with the rules of a court may be just an irregularity, which can be waived depending on the peculiar circumstance of the case to meet the ends of justice. So in the instance, I don't know the Rule 11 that we're talking about. Are we going to consider it as an act of a parliament or a rule of a court? So if it is an act of parliament, obviously, as I said, conventional rule is that the judges are going to regard it as a fatality, and then they actually will throw out the particular issue in whole.
Okay.
But again, if Rule 11 that we are talking about come to being as a rule of court, not actually the main act of a parliament, my holding would be the Supreme Court would have just helped us to go and hear the merits of the case so that we can set the various legal parameters for litigating petition issues. This will be a very good opportunity for Gambians to at least get a jurisprudence on this matter. But unfortunately, as your panelists would agree, this is a big blow to every legal person in the Gambia.
Yes.
But the law is law as it is. So, and then these judges also actually, for me, I wouldn't say anything of bias would come on their way. I know most of them personally, so I know how credible they are. But for the good of jurisprudence, we would love to see as lawyers for this to go into full-blown trial.
Yeah.
But going back to the question, I want to ask your panelists, are we looking at Rule 11 as an act of parliament directly, or we are looking at as a rule of the court? So are we going to approach it as a mandatory, that is the non-compliance of this particular rule should necessitate the throwing away of the entire case based on the rule of fatality? Or are we treating it as a rule of a court, which actually would be what we call directionary? We have what we call directionary and mandatory. So this Rule 11, is it a directory or is it mandatory? I want us to go into fatality. They did very well, but actually I would like them to expand on the issue of fatality.
Okay, let me throw it at Mel.
Yeah.
Mel, go ahead.
Sorry, I was just doing my own little research here, and I just wanted to Lamin. I think it was Lamin or Sarjo, but I think it was Lamin. I'm not sure that mentioned, because I think we have to be really fair and get into this matter, because I and Lamin have been talking about this for a while now. But Lamin is very passionate about this, and knowing Lamin, he's pursuing it relentlessly. I've seen his Facebook post and everything. But Lamin, let's get back to the Pinochet case.
Yeah.
Amnesty International, and Sarjo, you can correct me.
Yeah.
Was Amnesty International not a party?
Yeah, don't forget the question. Do not forget the question. Let's save the question.
No, I won't forget. I won't forget.
Okay.
Was Amnesty International, and this question is both to Sarjo and to Lamin, was Amnesty International not a party to that suit?
It was a party to the suit, as
was
far
a
as I
party.
can remember. Yeah.
Exactly. And you know what the distinction is in this matter before the Supreme Court? Malik Jallow is not a party to the suit.
No.
Hang
no.
on. No, allow me.
Okay, go ahead.
I am going to give you the distinction.
Yeah.
In the Amnesty case, in the Pinochet case, Amnesty International was a party to the suit. And therefore, the issue of conflict of interest must and should arise. But the distinction in the matter, in the issue of the petition, is that Malik Jallow is not a party to the suit. If, for example, you had the first respondent as Adama Barrow, then you had the second respondent as Malik Jallow, then your concerns come. But Malik Jallow in this instance was merely representing his clients. And we all know, like I said to Sarjo, we have strict rules of procedure and strict rules of codes of ethics that guards a legal practitioner appearing in court defending their client.
Melville.
And so in the Gambia, you asked me, I told you I was going to do my own research.
Go ahead, sorry.
So in the Gambia, Lamin,
yeah,
a legal practitioner who is not a party to a suit and merely representing the interest of his client in court, the issue of conflict of interest does not arise. With respect to what we have now, either in the Legal Practitioners Act or in the Code of Conduct of 2011.
Okay, and the judicial, in the judicial conduct we have here, again, look, I keep saying the UK. I'm not familiar with Gambia, but Gambia is a common law jurisdiction, and Gambia adopts a lot from the United Kingdom. Yes, Amnesty International was a party to Pinochet's case. In fact, the links between that judge that was in the panel and Amnesty International was very remote. It was nowhere as close as the IEC representative. Remember, IEC is a party here, but who is the face of the IEC in that court?
No, that is in law, that is irrelevant. That is absolutely irrelevant.
It is very relevant, Melville.
No, it is not, Lamin. I will argue with you till doomsday. It is not relevant. Party, Malik Jallow is not a party to the suit.
Malik Jallow has an interest in this case.
No, absolutely not.
Malik Jallow has an interest in this case, Melville.
Absolutely. You cannot compare. All I'm saying is you cannot compare. As a lawyer, you cannot compare.
Have a look at the judicial conduct.
Lamin, hang on. I don't have to look at anything. As a lawyer, the only thing I am making, remember, I had already put my position. I agree with all of what you guys have said. I have told you what is the position of the law in the Gambia as far as my knowledge takes me. But what I want to address is the distinction you try to draw in terms of comparison between the issue of the Pinochet case and the issue of Malik Jallow. And I'm telling you that it is fundamentally distinct and fundamentally different in the sense that Amnesty International was a party to that suit, whilst in the issue of the petition, Malik Jallow is not a party to the suit. That's all I am saying.
Melville. Okay. I just
wanted to make that distinction.
Okay.
And for you to say that they are the same, I wanted to say they are not the same.
Look, they many cases, like you'll rarely find two cases that are exactly the same. There'll be differences here and there, but the principle here is basically down to the laws set by the judicial conduct. Simple as that. IEC itself never turns up in court. IEC is just an institution. Somebody represents them, and that legal representative is what we're talking about here. So now Amnesty International itself is an institution. Somebody represented them. Somebody sat on that case who had remote links with Amnesty International, had a wife or relative who invested or who was a donor to the Amnesty International prior to the case coming up. Now, in the case of the IEC, Malik Jallow is not even remote in terms of relationships between him
but
and
Malik
the guy.
is not a
IEC
party.
is the party here,
But Malik is not
IEC is
a party.
representative.
The relationship in the Pinochet case was with Amnesty International as a party to the suit.
But that's
the relationship in this case with the petition, there is no relationship between the petitioner, between the judge and the party.
So now,
it's not the same.
Melville, the relationship is pecuniary between the judge in a panel of 5 judges and the Amnesty International. The relationship could be personal between the Chief Justice of the Gambia and his son, could be financial interest.
The son is a counsel receiving attention. Receiving instruction.
But the judicial conduct specifically.
What your judicial conduct in the United Kingdom you're making reference to has no bearing to the one in the Gambia.
I think it will have. Well,
do not think you have to be factually sure and correct.
Yeah, but you're not giving me any statute in the Gambia.
Okay. Hold on now. We will come back to this because it's also important.
Okay.
Guys,
Sarjo, we have a caller.
Let me just the question at least. I think that's more important, and then we can go back to this.
Yeah, we can go back to that one.
What Famara said is
I will pick a few calls.
Yeah, what Famara said actually makes sense. That's contemporary jurisprudence. You know, we don't let technicality stand in the way of justice. I think it's even part of Supreme Court Act. But here, Axis said, you know, like a violation of a statute would be fatal, as most courts would say, rather than just a mere rule. The distinction is, and then in their justification, Supreme Court says in the Gambia, you know, the Interpretation Act, I think Section 14, made no distinction between a subsidiary legislation that, you know, is a byproduct of the Parent Act itself, and then the rule. And in Gambia, the rule itself, you know, the Election Act says the rule-making authority can make rule regarding election petition. And Chief Justice is saying that's a subsidiary legislation. And then as far as the law in Gambia is, there is no distinction between that subsidiary legislation and then the Parent Act. And then, in fact, he made citation to that. In addition to the Interpretation Act, he cited cases where they says there is no distinction between the subsidiary legislation and the Parent Act itself. And in fact, the approach in their jurisprudence in Gambia and then the cases they rely on as persuasive says that those rules must be construed as if they were enacted under the Parent Act. So in essence, he's saying violation of Rule 11 is a violation of the Act itself, no distinction. And then that's his position. But my point is, courts have powers to make rule as part of, you know, the Constitution will tell them to, you know, administration of justice. And then most courts routinely do. They make rules for civil procedure. The problem with Gambia is, even if you look at Criminal Procedure Act, those are actually legislation. Whereas here, they would be, you know, written by courts as part of, you know, judicial procedure. So it's very difficult. Gambia, most of the time, legislature would make acts and then says that we are going to make rules regarding how you would implement this act. But they now delegate that rule to the court to make. In as much as we call them rude, but they are still coming out of that Election Act itself. But I think what we could call as the rule itself might be the Supreme Court Act, because that has rule regarding how, you know, procedures should be governed in the court. But the election petition rule, for this case, Supreme Court considers it as part of the Parent Act. You know, that's what they are doing. And then I think that's the distinction the court tried to draw in that case.
Okay. Let me take another call. Caller?
Hello.
Caller, Todi Mado.
The Osman Barrow.
Barrow, every minute now. Bismillah.
Yeah, follow. Definitely I'm content about with your panelists from Roberts, Mr. Barrow and Tamba. Definitely, I'm proud of you and yourself, Binto. I can see we have well-seasoned Gambians, and then I'll just ask you to keep it up. So I'll kind of give up. I don't advise them in let nobody take it personal, but I'm sorry. Like, for example, I just want to throw this to Mr. Tamba. I really appreciate your argument, and then I see that the way you articulate everything, you are very, very well landed, and keep it up. So I'll definitely speak. I'm proud of all of you. But one thing, women for Lamin, Tamba Karol job, we are seeing you here as experts. And exactly the conflict of interest you was saying, it's true. But here, even I'm seeing conflict of interest because any topic that comes, I'm seeing him like he's defending the petition or whatever. But I understand he's a politician also. I know him. Okay, so but Jan Alem Demadrom, all of you experts, try to put your political affiliations. I'm very proud of I don't know Mr. Barrow, I don't know Roberts, but I mean I think when they are talking, they are more loyal and independent. But Tamba is more, he's always punching. And sometimes I want to ask Tamba one question. If you were the lawyer, for the defendant, like your legal terms, Barrow and others, if you are the lawyer for the PP, obviously, you will capitalize on this article number 11 because this is what we do in law. You will always try to look for the fault of your opponent because otherwise they'll cut your neck. So the fault, I don't understand. I go to Manika because I want many people to understand. What we have to understand, you people are legal experts, but a lawyer feel like a bank. Kito lawyer feel like a bank. Do fasaka. So Lamin B, need to be Barrow la Carolano. If you contact the Mr. Coming, you not try to say that they go forward for the marriage. No, because but let's understand also this is an election. Election in petition. The last time I watched, I'm for 100%. I think because the example courthouse, it can balance all the balance so fair. So for so the country for petition on. One important thing, counting, that's very important. What is overwhelmingly correct? No, so okay, now they come to these small articles or this kind of legal terms. So need Jordan for your because the law is there for the security of the state. Let's not forget that. So need a balance. Okay. But then because balance at courthouse. Majority be it will bring test to the country because of only one article. The judges, I think, but I think they calculate all these kind of things.
You think they will rule on that like that? Okay.
They will not rule. They will not rule and make a ruling. I think if I don't get me wrong.
Okay.
And secondly,
did you think they ruled just to keep peace in that country?
No. I'm saying, judges, this also.
Go ahead, Barrow.
It's their mandate when they are judging. Also, they have to look at the consequence.
Okay.
Okay. When we come to the conflict of interest. Okay, I support Mel on that side because I can be only gentleman for the fine. But let's not forget that has made history like you Tamba, you Roberts, you Barrow. He paid his license to conduct. He's not a party, he's not a summon. He is representing somebody because for example, say I see your general choose. How can you say that no, you don't have the right to pick that lawyer because his father is the judge? Will that be fair? I thought lawyer left killing. Fuller. For analyzing him in Joe. Loi nyanta block la ba jumal defend no or abikiri jumal atanola. I want you people to answer that for me, please. Okay. And then I thank you very much. I'm very happy. I'm proud of you guys.
Okay. Don't go.
I just give you that advice.
Barrow, hold on.
Barrow, don't go.
Yes.
Barrow, in fact,
okay.
I was going to ask to make a point that I saw just now that
okay, but on the TV call, yes.
That UDP lawyer Usainu Dabo is from Bansang. He's from Bansang. The Chief Justice is from Bansang. They are friends. They grew up together. Is that not conflict of interest as well, going by Lamin strict
Okay. So what I will do, I will let Barrow go.
Two people asking me questions. All right, let me start with Barrow. All right, and I'll come with Melville.
Okay.
All right. Barrow, go. Yes, Tonyalem, Nimbe Barrow side. I want to win the case for Barrow, and I'll pick on those technicalities. But nga fole jang amamme, go. Ninga lual jube strictly with Rule 11. Yes, Supreme Court ye fenkonyi bondi nyameng. They're not wrong. Bante kamen fonunje. Na keta nung atuta nung fending killing. Fengo be keta fo atuta ka serve Barrow kang. Mo fulol membi je Attorney General ning IEC ya soto. Just Barrow tale ma soto. Supreme Court said time extend no le demanding. Porka 5 days di Barrow la. Security of cost nying ka fenke. Ka then as a reply. Wa molko Supreme Court ma sembo soto porka time nying extend. Nteko nga jubero ke nyame. Esa extend no le. Yes, Supreme Court is not wrong. Ngao fole nunjang janim na first kumo nga men fonong. Malafika Supreme Court muta unfairness to. That's what I said. That was my first line in program motto. Barenko nakata offending din netuta. Inyanta Supreme Court le nyanta wulila ye lawyer for mole ko nga continue nga ni election la petition no jube mune bije. For tonya sunya rocket la fa manke. Bara fele bi nte o jenola. So Fonka argument kele on behalf of Ntekamen support UDP bang no. Yes, lafta nung UDP a petition no win because ntole ni UDP benun doku wala. Pour a petition no nyinga continue to full trial because ntol nga menje je wala election no nyinga sunya tale. Okay, so ntewolon na sign woto nga continue nga tanyato. Melville coming from the same village or town is not one of the criteria set by the judicial conduct. No.
What judicial conduct are you referring to?
The UK one. So I'll give you the benefit of the doubt that the Gambian one.
Which is of no relevance to the Gambia.
Okay, yeah. So that's what you're saying. Until I come across, I'll make research into the Gambian judicial conduct if possible. But let's suppose we're doing what the Commonwealth countries are doing, right?
Are you saying, wait, in fact, what you said, sir, is not factually right. You said the UK, go back, okay, you said the UK Code of Conduct does not frown upon people being friends?
No, I didn't say friends.
Yeah, but
I said saying, coming from the same town.
Yeah, but I'm saying, if you were to go by your argument, and I think we need to move away from this, but if we were
so
to
are you saying Hassan Jallo and Hussein Dabo are friends?
They're friends, yeah, and that's
well, again, so we have two conflicts here.
So Lamin, who will sit for this thing?
So therefore, Hassan Jallo has offended two principles here. You understand? Yeah. You dug a pit for yourself, Melville. So if they're friends, that means Hassan Jallo should not be there.
Okay.
He's conflicted in two separate ways.
Please. Atala. We have another caller on the phone. Caller?
Hello?
Todi Madu. Lamin fit jambe kanderende korita wantara sumiyala kono. You have a question?
Yes, no, love the comment not direct. I'm in a program morning, alhamdulillah, it's very interesting. Buffalo and Kabili beginning. I'm just get a comment. Laughter comment, yeah, laughter man until the meaning movement. You see, you have to blame the UDP lawyers. The UDP have a lot of lawyers. There's a lot of lawyers, Melville from Alma Metal, different lawyers who were in the Supreme. Some of them were judges. So this technicality error, they could have avoided as much as possible. I don't know why. Your mistake was communicable. And secondly, Lamin, I think Lamin is a good person. I followed him somewhat, but of recent, I think I'm emotional in most of his analysis. I think he has to learn to control that. When we are not at political platform, we are an expert level. You just think like an expert. Don't say, yes, I'm not. I'm not saying the judgment is not this. But your question is about the judgment, whether it is right or it's not right. Let's only debate on that. Judgment on is not. I am not disagree with that also. But I believe they should do this. This is a rule. This is a law. So we should not just flood the law for our emotion or our personal interest. Everybody knows that, yes, this is a very interesting case. Everybody wants it to happen. But if the lawyers of UDP, with all the know-how and the trust we have in them, fail to comply with the law, the only option is to throw the case out. For me, that's my opinion. So, yeah.
All
So I
right.
thank everyone. Yeah.
Thank you for your contribution. Okay. Lamin.
Yes.
Before we let Sarjo come in,
Yeah.
Somewhere saying maybe the ruling, the judges did this ruling just to maintain peace in the country. Did you also agree to that?
No, I don't agree with that. I think the judges followed Rule 11 strictly. Okay. So whether it went for NPP or it went for UDP, I mean, I want people to understand one thing. They keep saying I'm sentimental and emotional, but I am very tolerant. It takes a lot to get me angry. So what Gambians term as sentimental or emotional or arrogant is somebody who's blunt. All right. So if an 80-year-old says something, you're not supposed to say he's lying. But when a 20-year-old says the same thing and it's a lie, you're supposed to tell a 20-year-old you're lying. They're two different things. I am not diplomatic in some things that I do. Yes, I agree with that. I should be like Melville, who writes like formally and leaves it at that. I am different. I do things differently. If you lied, I'll say you lied. I'm not going to say, oh, based on law, so and so and so, I believe somebody should do this and this and that. No. Everybody's got their approach. You go on Melville's wall, he writes formally, and then he leaves it for people to knock themselves out. I will come with one punchy line, 2 lines, and people say, why are you calling a 70-year-old a liar? Do you agree that what he said is not true? Yes, but you shouldn't call him a liar. So that's the difference. I am very, very, accommodating. What I don't do, because I've got a lot of following on my wall, including children who follow my wall, especially my son's schoolmates and my daughter's schoolmates. So I don't allow people to come on my wall and all they do every time is insult or perpetrate tribalism. I will move those people from my wall and block them. But other than that, anything else you call me a liar, call me whatever, that's fine. Okay. Just don't go instigating tribalism. Or every single comment is an insult. No, I leave it for the benefit of the majority and remove you. Simple as that.
Okay. Hold on. Okay. Caller, Todi Mado.
Yusuf Alem Sanyang.
Sanya Brimintina, please. Any language.
Alvenyali. Yeah, I'm good with the Mandinka.
Okay.
Mbala program on la way kang ila panelisol iba overtry kan ntenga one concern na sort of left am isla. Tolman ke loyalty mang lua fanan karambari ngalong rules are just rules. Iba tilinda la wala ya jankende. So nita ba jankenda wala side fault ke telema. Well, I was expecting more from the other camp. Many a mistake, okay? Because ila team of experts, team of lawyers. And Lamin Tamba was also in the picture. So nga mera mana mela nata nyama inja mala fo dola moro lenya inyama mala. Yeah, so verdict nyang Lamin should agree on the verdict whether it's okay, whether it's not okay. But rules are rules.
Okay, thank you.
So mbading mantera nung UDP la lawyer sol kono nga evidence so men soto nga wala submit UDP la lawyer sol but the procedure ning I was not familiar with the Supreme Court procedure and the election petition on the only thing is na keta nka luwale jube nga long for atamandita luaya for nyama for amantama nyama but I was not part of the preparation of the case to submit it to the Supreme Court. So I didn't know what was in it. Thank you.
All right. Hello, caller. I'm just going to take 2 more calls. Then
hello. Windows platform.
Sorry, madam.
Musa Ambai.
Mbai Brimintina.
Anka ko platform kashabe bete aranga be nice.
Bismillah.
Bela panelist will be control now.
Okay.
Coming more la for also maybe dia jube atebe dia mo kanyame coming ko maybe abe UDP la fasata but okay again ni nata ntefe Melville fananka muntala ko me alon ko is defending the NPP.
Okay.
The only guy the other guy I don't know
Barrow.
wala wodi tafe wala be professionalism penchakanjang, you know, but both sides be more flawed wala kala na ko yindo beta na yindo beta to be honest ita nga len ko me flokan yes what am na contribution on but kacha beta mbake ya bonyo nyota na lo.
All right, thank you.
Binto, can you translate that for me?
Yeah, he's saying that hold on. Caller, hold on. He's saying that he think that you are defending MPP and Lamin is defending the UDP. So the person that's neutral here is Barrow.
Can I just respond to that?
Go ahead.
Hello, Binto.
Caller, hold on, sir.
You see, for people that don't know, and I know Lamin was just talking about his own issue. For me, I am not bothered about such comments because, as far as I'm concerned, and those that know me know I am not defending NPP. What I am defending is what I know as the law and my understanding of the law and my understanding and support of the ruling of the Supreme Court. If anybody thinks because I am siding with the law, I am siding with NPP, that is fine. It is their right to think so. But as far as I'm concerned, I came out publicly to endorse lawyer Usainu Dabo for president. And in fact, I had a discussion with you prior. You gave me your own advice, and I said to you I was going to do that because I was going to do it out of conviction. But when UDP rejected the election results, I was the first person to come out to say that I do not support the rejection of the election result. And I was unapologetic about this because I did not believe there was need to come out. In the first instance, I had issues. I had substantial issue with the fact that UDP came out with a public statement to say that they are rejecting the election results, and then went on to say that they are gathering the evidences. And I went on my post to say that I believe that you gather the evidences first, establish that there were irregularities first, and before you reject the election results.
We had that discussion here too. Yes.
You do not reject the results, reject publicly the election results, and then tell people that you're going to gather the evidences to establish and substantiate the fact that you have rejected the results. And I have said this and I made it clear. And now I am not a dogmatic follower. I am not a person that because I support lawyer. If you have a rerun of the election today and you still put lawyer Dabo and Adama Barrow, I will still choose lawyer Dabo over Adama Barrow because of my own personal reasons. And I stand by it and I'm apologetic about it. But it will not make me, because I am supporting lawyer Usainu Dabo, it will not make me be blinded to the fact that the lawyers of the UDP, they missed the plot. Because as a party that can boast of highly reputable constitutional lawyers, people who follow rules, who follow procedures, I do not think they should have got this wrong. Because if you look at the submission, the application of the respondent, you can tell that they did their homework right, in that they knew and studied the rules. And if you ask Lamin, who's on my Facebook post, I said this. Initially, the matter started. I said that it was going to be a very interesting matter because I know lawyer Ida Drame. I have worked with her. And I told Lamin, even before coming to the substantive issue, before coming to the merits, she will look at every bit of procedure and technicality. And if there's any, she will flout it. I told them she would not sleep at night. She will go over every simple detail. And as a lawyer, I know we are all arguing, we're all talking about merits, we're all talking about other things, but we all know factually that as a lawyer, you need to respect the rules of procedure in court.
Thank you. Thank you.
And I can agree that Melville is not arguing on NPP's behalf. I was just jokingly saying he's an NPP lawyer.
No, he's not. He's been we had two discussions with him before today on this issue. So hello, caller.
Hello, Binto.
Todi Mado.
Aziz Bojan nemu Halifax.
Bojan Ibirmintina. Any language.
Ha Emila Panelist Olube Kontona. Kacha Diata back. Ntela intervention de kela komen diamula men tambita lafta kawale jabi domanding.
Okay.
Ka fay ko panelist olu men bebe jang iba kata come back adunte man any bias je ila karola. Lamin la intervention, even though seems to appear as a bias, it gave opportunity for other two panelists and it challenged them to come up with case laws and jurisprudence that will enrich our knowledge.
Okay, great.
But just because something is not going your way, or doesn't mean that the person have that particular bias for that. Nteamera in case iba diagnose kanyame is very rich. Adun tumodo fang aseke jojo dol fana bela moy kangala. Bari luwa mumenti mobile ka karambari bukaban.
Yes.
You can rely on a certain judgment at a particular time. Modo ning another perspective or another judgment men strong to itati can come up with it.
Yeah.
Yes, adungaji kiko this election petition was a great opportunity to challenge na electoral laws in ways mea lonko. It could have been a constitutional writing moment had it not been thrown out on technicalities.
Yes.
That is not to say Koninga Tata Fana, the plaintiff would have won. No. But probably issues of jurisprudence, issues of best practice would have arisen out of it that will enrich our democracy and our electoral law. That's a lot of opportunity. So Ninemu the only opportunity in Semensoto to diagnose.
Thank you, Boja. He's saying that the discussion is very important. The discussion we just had is very important. It's not. He was responding to the guy that that call that you respond to. Yeah, Tamba.
Yeah.
Sarjo, what is so important about this case that we need to review before we close the show? I have one more question. What do you guys want to tell us to pinpoint for us before we wrap up?
Well, at least, one thing all practitioners in Gambia would know from this case, in as much as it has been struck out at the early stage, that the court has, hold that the Rule 11 of election petition rule is not inconsistent with the Constitution. And then the court has hold that strict compliance with the rule is required. And then lawyers would know that going forward, election petition you must serve. And then most importantly, in Gambia, Supreme Court says that personal service means service on the person. There are no exceptions. You must literally serve the other person. And then the only exception they carved out in the rule is saying that because president is such an extraordinary person, service on ally you will be accepted. They deviate from the standard and then they accept that. But it prompted me because I was a little bit, dumbfounded to think personal service means service on the person themselves directly, and they're not even with adult person in their home. So it begs the question out of this petition, does that mean service on the vice president, the minister would have an exception? Where do you draw the line? We don't know. And then on the High Court Act, which is not applicable in Supreme Court, what I do know from Order 3, Rule 1, it says personal service means service on the person. That's something our National Assembly should look into. I think that is fatal. And then because we copy and paste from 1800, that's still there. 2, the other thing that's not clear. In the ruling, Supreme Court spent so much time justifying that the amended petition was timely made, meaning within the Section 49 ambit, the 10 days period. To me, I see that irrelevant. It's really, mind-boggling. All what the Constitution requires, you must file within that 10 days, and then you do. If you want to amend a petition, those amendments are governed by the rule. And I don't think that statutory 10 days period is relevant in terms of amendment. If you do it under the rules, with leave of court, which the rule says, there is no limitation on when an amendment must be done under the rule. But somehow the court speaking in dicta make it seems like even if you are making an amendment, it must be within that 10 days. I haven't seen any cases that support such an argument, but that's still not clear, and we don't know that. The other thing that is not known, even though this thing is made, whenever you file election petition, since our court has not done their job in setting what the security would be, does it mean petitioners now have the burden to actually request from the court what the cost would be and then make sure they comply with Rule 11 within that 5 days? Remember, the statute or the rule doesn't explicitly, put that burden on the petitioner. UDP, they have smart lawyers and proactively, made that application, but it's still not clear, how we go from here. So a lot has to be revisited in our rules to make sure they come in compliance with, all what is happening, because I think that is the problem we are having in Gambia. There's a lot of vagueness in the law. Let me put it that way. The only thing that is clear from my reading, there is no rule explicit of the Election Act, election petition, or even under Supreme Court Act that gave general power to Supreme Court to enlarge any rule. That's not there. At least that is the only thing that make this judgment a little bit, you could say it's okay, it's justified, and then it is in the majority of all the rules. And then the turning point for Gambia, what we should learn, the cases Supreme Court rely on, and all the jurisprudence that back these things, all of those countries have come to realize there is a public interest in hearing regulations about election, and then they specifically carve out a rule allowing courts to enlarge time if there is a need to do so. So I think this is a learning opportunity for National Assembly also to look into this thing and say, we are going to change those things, and then doing so would be in substantial justice for the whole country. I think that's what we can learn from this, petition as it stands right now, from a legal standpoint. When I'm looking at it, that's how I looked at it from now.
All right, boss Mel. Before we go, I have one more question, but that question, when I bring it on Gambians, you're going to speak as Gambians. But right now, go ahead. What would you point out?
It's exactly what he has said, save for the fact that even the courts did say, and have interpreted it to mean that service should be on the person, but they went further to say that except where the petitioner would have come back to the court and make an application for substituted service. So they did say that. So yes, it's on the person, but they could have made an application for substituted service. So that is just there. But again, what he has said basically is what legally is what you can deduce from the ruling. Like we said initially, it would have been nice, it would have been interesting. In fact, a lot of people were looking forward to the case being judged or adjudicated based on its merits, and we would have a lot of things that would come out new to govern our elections and or election petition, but that was not the case. But again, this is the law, and we all know that. As lawyers, so many lawyers have relied on technicalities in court, and they would celebrate it when it is in their favor. And I believe absolutely that if there had been any issue of technicality or procedure in favor of the petitioner, it would have been celebrated as well. For example, the issue about the cost of 10,000 when the respondent withdrew, that was procedure. That was not substantive. It was procedural, and it was celebrated. And I did make mention, again, that let them celebrate as much as they want. But just as you celebrate, when it comes to bite you again, you should be prepared to celebrate as well. So really, for me, that is all there is to it. But I think we have all learned. I think next time, I think the UDP, they missed on this one with respect to the strict adherence of all the rules and procedures that they should have done. And I think they have learned from it. And I'm sure they will come back, bigger and better. But that's just what it is as of now, until the courts would, we have another petition case where they will depart from whatever it is that they have said. But for now, that's what it is.
Tamba, what would you pinpoint and why GDC did not go solo, but they went through, they joined the UDP, and nobody even knew about that?
Yeah, so basically, for me, like I said before, the legislation has to be consistent with what the Supreme Court Act says, what the Election Act says. We need to get a little bit of consistency. One cannot tell you serving on the registrar is sufficient and the register has to do this. And then the next thing, election rules come in. The Constitution there's no conflict in regards to the Constitution. It was fine because the Constitution just said basic. If you're not happy, petition within 10 days, period. So it's the other laws that should expand on it. The Elections Act has done that. Rule 11 has cost us this petition. So therefore, I think Rule 11 needs to be expanded on in terms of costs and all whatnot, I think. So generally, it's a reform issue. If our parliament is serious about it, the speed at which they change the age limit on the Constitution, if they can adopt that same speed, they could bring all these acts in line before the National Assembly election. All right? And the speed at which they amended the deposit to contest as an MP, if they can act on that same speed, we'll have better laws before the National Assembly elections. But then again, are they going to change it, knowing that they could play the same games of giving people inducements, enticements, bribing, and all whatnot? They won't want to reform it quickly. But that's my personal opinion. So, me personally, I think general reform, needs to be done.
Okay.
All right. In the UK, years ago, apparently, when he's serving a writ, writ of summons, you need to go and slap it on the person himself. So basically, the people who serve it have to go and wait at your gate.
Yeah.
As soon as you're coming in or going out, they just slap it on you like that. But with technology and tracking of Royal Mail parcels and advancement is in instantaneous communications like emails, all that was reformed. So UK reformed a lot of their laws in the late 1980s, mid 1990s. A lot of law reforms took place. So they made things easier for you to serve. If you send it via post, if you send a courier, whatever you do, as long as it's certified and it's gone and it's delivered, it's fine. But election petition is different. Again, we can reform it. So that's my. But reason GDC, APRC, GAP, and the independent didn't go it alone is because of financial stress. This was a highly charged political case, and all the lawyers were looking at the risk of the cases in terms of their careers, their law firms. So they were charging a lot of money to be able to put this petition forward. So we decided, you know what, we're going to have the same challenge as the UDP. Whatever information we have, evidence, we gather that and send it to the UDP. And we had some credible, compelling evidence that we gave to the UDP. But again, we will not know that now. I can talk about it now, but anyone can just jump and say, oh, Lamin, you're lying. It would have been different if the court heard it and said, yep, this is corroborated. We believe in it. Well, therefore, we're going to have fresh elections altogether, or we're going to conduct elections in so-and-so constituency, or we're going to do a recount in so-and-so constituency. Those were the remedies that we would have had from the Supreme Court, but we will never know now. So in my view, Parliament should sit immediately and review all our election-related laws and make sure they're all consistent across board. Thank you very much.
Lambert, to that, just to add, this is where, like you said, changing rules. Gambia, the problem is UK has the same old laws. And then in Absalom v. Gillette, that came before, Ulada in 2002 in UK, before they add Section 19 to say that judges have power to enlarge. Judges would show they are discontent with a rule that is so draconian. And then in Absalom v. Gillette, the UK court did exactly that. And then they expressively say they do not shy away, from the disparity between the need for election petitions to be heard immediately and then the public interest underlying it. And then they could not reconcile it, but their hands are tied. and then they do so, struck out the petition because they do not have judicial fiat to do that. But they call on National Assembly to do so. Like, hey, change our rule. The contrast is in the Gambia, in as much as our court did not lay out, like the court did not speak to say, hey, look, we find this rule abhorrent. It would appear the court is content with the rule. I mean, stare decisis is all good. We want predictability. But the signal, the policy you could take out of the ruling, the court is saying, we appreciate this rule. We want this rule to continue. And then the deficiency we have in Gambia, our National Assembly, when they make these laws, they are not experts. The good news is now we have National Assembly Service Act, and then that's going to give them that division. But until then, National Assembly, when matters of courts come in, they delegate some of those authority to judiciary to make this rule. National Assembly should have made this rule, but in the Election Act in '98, they say, hey, look, make rules regarding election petition, because they were relying on the expertise of our judges. But because we are so lazy, we went and copy paste someone else's rules, and then without actually thinking about it, and then they are lying over there. These rules were not made as part of consultation. Most of the rules in the Gambia, they are from 1933, when things were done in England, and then we are still suffering from the same thing. I think the new approach would be National Assembly should start reviewing this rule, or there should be, like how we have in the US, a rulemaking committee to review judicial rules and all those things, to amend things. I think that's going to be of great help. And then they themselves, they are coming for re-election, and then some of these things could come back.
They
and
will feel it.
them. Yeah, so I think it's about time we start, taking responsibilities and then making things, the way it ought to be.
Yeah, I'm telling the community here, Mbali Jaila, we have one more case in the court, so our legal team will come back one more time. I don't know, 2 more time or 1 more time, but they're here to stay. So always follow us. You will see Fridays what will come up on Sunday. So we appreciate each and every one of y'all, and share, follow us, and subscribe us on YouTube. Mel, before we go, this time speak as Gambian, no lawyer on this one. Politics have divided Gambians, families, communities, I mean, tribally, friends. I don't even know how to describe it. But as a Gambian, what would you tell the citizens? How do we reconcile? If the president is watching now, what would you tell the president to prioritize to reconcile our country?
Well, I think you are absolutely right. I think the Gambia at this point is deeply politically divided. I mean, I think our understanding of politics has gone beyond the realm of the political terrain and has extended to personalities and personal lives and personal relations. So, for example, and I'll use this as an example because he's my friend. You can see myself and Lamin, like we would argue heatedly, I mean, passionately over issues, but it has never affected our relationship. So I can tell Lamin that I disagree with him. He would come out and tell me he disagrees with me. We would not agree on things. Sometimes we would have to argue for like an hour before we could even come to a convergence at some point. But it has never affected my personal relationship with him because we're able to distinguish between the issues at hand and our personality and our relationship. In the Gambia, it's very different. I mean, I have seen people that were very close to me, but because I came out and publicly endorsed Lawyer Dabo and they probably NPP have decided not to have any sort of dealings with me anymore. And I have seen people who probably didn't even want to speak to me, didn't like me, had no sort of dealings with me whatsoever. But immediately I came out and I endorsed Lawyer Dabo, they all embraced me. And of course now, because I am saying that I agree to the ruling of the Supreme Court, they have gone back to their corners because they feel now that I am NPP. But this goes to show
the level of awareness, the depth of knowledge base between individuals understanding these issues. But you cannot blame people because we never had this. Our politics was never this open. I mean, now we have social media. We have a university that's producing a lot of Gambians who are going to school. They're studying, understanding political science. People are more involved in the day-to-day governance, day-to-day issues that are surrounding, the country. So people are more passionate. And then, of course, people saw what happened in 2016. And now Gambians know that, a lot of things can change in elections. So people are more interested in the politics. So what we see is not uncommon. And like I always say, that it is good. I mean, my brother Lamin likes to take a lot of cue from the UK. But I'm glad that he said that at some point, for you to effect service, you have to go and slap the sermons on the person. But things are evolving, and I believe that Gambia would evolve. What I feel is that, is when people think that just because something is being done in America or is being done in England, and automatically we have to see the same, no. I mean, there were times when I always say that in America, it was only a man that could vote. You understand? You only had to be a white man to vote. Then it was only yard owners. I mean, it evolves, and then it included women, So eventually we will get there. Like all the panelists have said, and which I subscribe to, is that there has to be a fundamental overhaul of the rules. We have to look at these. Some of them are very archaic. Some of them have gone out of touch really with reality. So at some point it will get there. So people are just passionate about things, but people don't understand the substantive issue with things. So what I would like to see is for your party militants, to come together, you have to see a semblance of acceptance from the political leaders, the political actors, the players, the shakers and movers of our society when it comes to politics have to be together. And that is why in America, most times you would see, no matter how heated, no matter how bad it is. I mean, I remember the elections with Hillary and Trump. That was heated. That was fierce. You understand? But at some point, for the sake of peace, you would see leaders congratulate each other, call each other, extend, a hand to each other. And I think this is what we need to see. We need to see and understand that, yes, there's a time for politics. But again, there's a time when we all have to collectively come together to put whatever, differences we have aside and work towards a better, progressive and more successful Gambia. Because at the end of the day, it's not about politics. It's not politics that binds us. It's our Gambianness. It's our oneness. It's the Gambia, the country, the Gambia that binds us together. So at some point, we need to be able to understand that because I support a particular party or because I am a member of a particular party does not necessarily mean that we have to be enemies. We just have a different opinion, which we are entitled to. You must learn to respect the other person's decision to support whatever. I mean, even if I have a child right now and they want to support GDC or they want to, I'm not going to stop them. It's not because I have a different perception, so I'm going to instill my own thinking into somebody. It would have been very easy, trust me. It was more fashionable, more advantageous for me to come out and say, and I have so many friends in NPP, and come out and say, you know what, I'm endorsing President Barrow. It was the incumbent. It was more, I mean, really, if you look at it, me and Lamin, if you talk to him, I said to him, personally, and now I'm saying it publicly, I told him that I believe President Adama Barrow was going to win. In fact, even a few days before election, I called Lamin. I said, if you want to unseat President Barrow, all the coalition, GDC must come, APRC, and join UDP. I said that. But again, certain things are done out of principle. And me, I believe in my conviction. So just because everybody is supporting a person who most people think has the advantage to win, and I want to join the club, I want to be fashionable, it's not going to make me do that. So in the end, in the final analysis, I think we should all know that, yes, he has won the election. He's got a mandate for another 5 years. Do you have to sit back and be hateful and say you're not going to talk to this person? That is not even good for your mental health. As Gambians, we need to come together. We need to know that there is more that binds us than what separates us. And we need to know that politics is politics. It must remain in the realms of politics. Our personal relationships go beyond that. We must need to respect each other. We must need to be tolerant. We must need to exercise restraint when we express ourselves. And this, and only this, would make us see a better and more productive Gambia.
Thank you. Tamba.
Yes.
If Mama Kande
Yeah.
will stand, Honorable Mama Kande will stand right now, and Honorable Dabo, they will pick that phone and call President Barrow and congratulate. Will that help the country?
Of course, it will help the country. I mean, both of them have thousands of following. So if you put Mama Kande's votes and Hussein Dabo's votes together, that is about 300 and something thousand votes together. And that's a good number of voting age Gambians. So if the victory is nice, clean, and they pick up the phone and say to Adam, well, congratulations on your election victory. We wish you the best for the next 5 years. Why not? A lot of people will just move on. Again, we'll come back to the same issue of reforms. I believe we should be able to elect the president and National Assembly members same day. And then we can bring back local government elections a year nearer, all right? So that it can give us a clean 4 years of concentrating on development and community work only. Because right now what we've done is a presidential election. Before you settle down and inaugurate the president, the National Assembly election comes. Before they start their proper sittings, local government election comes halfway into the president's term. So it's like a continuous election cycle. It happens in more developed countries because they already have systems in place. We don't have that in place. So what Melville said is true. Melville and I will argue on something for a long time. But next minute, I'll call him to come and have a drink. He'll call me to go and have a drink. He'll invite me to his events. I'll invite him to my events. I mean, a couple of years ago, I contributed to somebody who needed medical help, and they were a well-known UDP person. APRC people came to me for contributing on the GoFundMe link. I said, why? Because they're UDP, why you contribute? I said, yeah, they're Gambian. They need medical treatment overseas, and they needed people who've got spare money or who can just dedicate a little bit of money to help them go and get treated. What's wrong with that? Doi came here, they invited me to go and listen to Halifa Saleh in East London, Stratford. I went there. APRC people were questioning, is this guy planning to defect to Doi? No. Look, today, even if you get stopped by a mad person and that mad person engaged you for 5 minutes and they're medically mad, you will learn something from them. You understand? Does that mean you're going to hang out with the mad person and sit there and get into rags? No. It means you're picking the positives and moving along with it. So Gambian people, and I mean, look, since July to December, you've seen what my own APRC people were doing to me. You understand? I stayed on the surface. Thank God they didn't have any personal information of mine to spray out there for the public view. I stayed on the surface. I didn't go into people's personal lives. I've got damaging stuff, but I grew up knowing I'm going to go from one rung of the ladder to the other by my ability, my skills, not by pulling Melville down, not by pulling Sarjo down. No, I don't do that. But if Sarjo does something wrong, Melville does something wrong, I'll tell them straight, in a straight line. I don't massage the truth most of the time. I say, nope, that's wrong. You couldn't do it. So we need to learn where to stop. There's a time for everything. Time for politics. When that stops, we have families, we have neighbors, we have colleagues at work. You know, we need to realize this is politics. Let's argue passionately. But it shouldn't get to a point where Melville supports UDP or endorsed UDP, because people sometimes tend to forget endorsement and being a bona fide member are two different things. All right. So I might be neutral. Next minute I endorse Barrow for just that election. All right. Or I'll endorse somebody else. That doesn't mean I'm a bona fide NPP or APRC or UDP. So people need to know, okay, this is where politics stops. Now it's time for nationalism. This is what our people don't do. If they can't eat the couscous, they'll put sand in it. You understand? That must never happen. If you can't eat the couscous, find another way of eating, like that proverb that says, Instead of feeding me, show me where you get the food from so I can get it myself. You understand? That's what Gambians need to know. For me personally, as long as you stay on the surface, you don't go personal, support your party if you want. You can even call me a liar. You can say all sorts of stuff. If you invite me to a naming ceremony, I'll go to it. You invite me to a wedding, I'll go to it. I don't care who's going to be angry in my own party. That's not my problem. So we need to ensure that at some point, the leaders can come together, have a drink or something, or share a platform when it's purely community development. You understand? But opposition must always hold the government accountable. We cannot have opposition sleeping on the same bed with the government. That's different from saying there's a natural disaster today. We can't help the government help the victims of the natural disaster. They're different. We can't say the hospital is dirty, UDP can't go and clean it, APRC can go and clean it, it's Barrow's responsibility. No. The organization that I work for, or it's called FAD, our executive members, some of them are GDC, some of them are UDP. So we work together beautifully for the last 2 years, 3 years. No problems. When politics comes, some of them, believe it or not, they blocked me on Facebook. But I sit with them on the executive of FAD and we chat. And we take the community forward. So this is what I want governments to get used to. Yeah, I'm going to block him because I can't take his wall politically. But when it comes to helping my own people on the ground, yeah, I'll work with him. That's not a problem. It's exactly the same mentality I want to filter. But if we have people like Melville, Sarjo, and yourself, Binto Bantaba Network, and we're spreading that message consistently, eventually the younger generation will learn. You understand? Reforms will come as communication changes, as systems change. We have to come up to speed. Sarjo mentioned the laws in 1933 in the United Kingdom that we transpose in the Gambia, or we don't even have to transpose them in the Gambia. We quote them straight away. So now is to look at the Gambian situation and say, all right, we're going to change this so it can work properly with our population being still struggling with literacy. We can change this to do this. Let's look at those laws and then we can move forward as a country. Thank you.
Thank you. Brother Sarjo.
Yes.
Yes, last question. Reconciliation.
That's important. I think it's personal and then individual tax. If you understand that, if you support a leader and then you support the leader because you share visions and interests, that's okay. And then you would follow that. But if, they are asking you to do something that's contrary to humanity, you have a divergence in policies and view. But Gambia, I think it would help if leaders, even after election, to show that, look, I still disagree with, president-elect or opposition-elect or whomever in terms of how policies should be, but we should both work together in terms of national interest. I still fundamentally disagree with the way they are going with it, but the results is, Gambia, and then we can see that help each other. But most importantly, I think the Gambia, the problem is the few, us, the ones that are educated. People are starving for information. And by information, I mean objective information. And then we are starving them from that. And then they start making their own opinion. Especially, with this election, I hear a lot of things that happens because public doesn't know what was happening. Even me personally, things that are like of public interest. And then if journalists rather are doing their fair share, giving population what the truthful information is, and they let the population consume it, political parties informing their supporters, this is what we are doing. Things would have been different. For instance, when this petition was filed, if there was a statement from the petitioner saying that, look, this is election petition, is purely statutory. This is what we are trying to achieve. There are some rules, and then we might not agree with the rules as they are right now, but this is how things are. That's going to ease the population to at least expectation. If you're a lawyer, you have an obligation to your client. Well, let me say here, under our rules of professional conduct, to manage the expectation of your client. You have to be very, very realistic. And then lawyers in Gambia and then the few educated, we confuse the rest of the population. We say things and then the population doesn't have the right information, and then that's create this frenzy environment we are having.
Yeah,
I seen people throwing words like, "Oh, he comes to equity must come with clean hand." If Barrow is stealing, you are stealing, why should we come to court? This is not about that. I mean, like, yes, they are true, they are general terms, but you have to put things in context. That has nothing to do with election petition. Or on the other hand, you could be like, oh, well, this is technicality, it's not substantive. We know that. And then those are general rules, but these are specific rules that, trump those things. At least it's going to manage the expectation of your clients. You could still have, valid claims, but at least explain it to people. Shall is a mandatory, and then that's what to me, like the friends I have, we might have a lot of difference in opinion, different parties, but I can interact with anyone. That's how I say it, because as it's fondly said in Gambia, shall is mandatory. I was like, says who? It could be directory, and then this has been proven in court, even late jurisprudence. But every follower thinks that if I'm following party A, I shall only ascribe to what they say. Anything else is not truth. It's an alternative truth, or is convenient. But I think it's time for Gambians to start thinking, outside the box. One thing I do fundamentally believe in: there is no shortage of intellect or raw intelligence in Gambia. The problem is we just have to be sincere when it comes to nation building, and then it starts with leadership. Our leaders are the one that should show us, put your money where your mouth is. If you doing this for Gambia and then things don't go the right way, still come back and say Gambia remains, will support, Project Gambia. We can still disagree about the way we are going to support it.
We are going to
fundamental, and then at personal level too.
That's why we appreciate y'all coming in all the time. I'm telling y'all, we do. Now, Mr. Roberts. Thank you. Tamba.
Yeah.
Sarjo, all I can say is just, we will be back here again. I know that for sure. They always leave whatever they're doing, work, holiday, family time, and sit here with us for 3 good hours to educate us. I mean, that's all I can say. Thank y'all. This is it. Thank you.
Thank you too. Thank you.
Thank you very much to the viewers and the callers and everyone, your channel and all the staff that work behind the scenes. Melville, thank you again. We have to have a drink soon. It's 2022. Yeah.
I would want y'all back. Yes, we have one more court
case. My birthday on the 12th, bro. So don't worry. I'll be calling you. We need to.
Yeah, definitely.
All right. Thank you.
Thank you.
Wow. The brothers, man. Go. Allah baraka. Ntola platform or to young awareness is available for each and every one of y'all. Binto, don't know much, but for sure, people like Melville will come. People like Tamba will come. People like Sarjo will come. So, and many more Gambians. So reach out to us. Reach out. This will help us. We have never paid anybody. Nobody's paid on this platform. The guests, Binto herself, my team, nobody paid us. But it's our responsibility to bring something up on this media that we will all benefit from. Ndolfanang, come during the beginning, no more control follow. It had in the video. Personal kuombuko kacha. Omantol sija. Because ntolla panye, ndefam kunkilong la panye, ninga lal kam, alta chikalano, ko botola. Wala nanka brother sol sambana, ye londo minu soto. It's a londo sotet. If a number min contribute, abe modo na fala, abe do fanan na fala, abe do fanan na fala. Ita fana min soto, a sambana. Alanga awareness create. Nyinyo nyiti nyito is not gonna work. Bare, nga kuja makaran, nga nyim petition o kachale, dal tata duma je, nga kachan ne nimmel ya kachan, ni Lamin ya kachan, ni Sarjo ya kachan. We have another court case. Left a point dole fanan sambala na mi alonko. Next Sunday nsa sambana ngo fanan discourse. Ntol topical. Mimbe caring. Dole ba vola yal nyin case tuje. Nyin case nta tula no je, my dear. Because mbake kan samala kam. Hani jojo fam. Bida be nyi ruling kela. I court do case do le court. I wole sambana ko nali nyin case dole jibe mbol ni nyun kun takel so ntolla jang be kachala ko kunata Gambia la be Gambian dingo na fa mbosamba mimman Gambian dingo na fa ntol mta interest to no bar hadama dingo lon tol fanante na kuma kango do bije ase modo balojan ise yam fan na kacha do bija se favor do bija te favor la nindala mita de mbe wakilla la ngalla moy because ase kenon se ku jama karanje nsolon din sotoje bar niyaje ko ita talano ise yam fo dimaso yomurun nan dimaso kote ntolu bijanne ni alamanta na ken ntolu be tarajan next Sunday alkana na kachamis bina kacha jama sambala lena bital loyal kamala nan kote. We have very important topic that we need to discuss with them again. Okay, so Allah baraka mafala mobe happy new year. Do not forget alin subscribe YouTube alkana nyina isaje nin nata dorong ibela ding 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 ila alarm ila fenkonyin abe signal o dile la ko Pinto Media Network mfela wultana nko nka jatolle sambananja mawoli sotot bare nka jatolle sambananja ikela londindingo ikela hajol tuje kana nibe Facebook fana yem follow isaje kanamis alkanamis. Okay, mo jama be call kala ali yam fanye ali yam fanye mbe kola so dol tala another time. Yeah, Allah baraka. Thank y'all. We cannot say thank you enough. Allah baraka. Do not miss every Sunday 6 p.m. Gambia time. Nibe dunia, anywhere you are, just compare your time with Gambia. Yes, share. This is not personal. You can share our information. We are here to stay. Yes. Allah baraka. Allah baraka, Allah baraka, Allah baraka. Okay. Matunga the best fan soul click bang. Keta. Mwah. Happy New Year. Yes. Sise. Mwah. Alwe dunia dawa dalama jedi alama funding kel. Gambian tolun solata peace lel. Mbenyim political party leader min my endorsement okay. Honorable Dabo. Be Danila. Yeah, congratulations, okay. Honorable Mama Kande. Ali wuli ntol Gambian dungol la ko kama. Ali president congratulate fintina nali banko doku. Benga denga banko do ntol bal Danila wal. All right? So it's gone, it's done. Mane, Allah baraka. Allah baraka, Allah baraka. Allah baraka. Thank you. Kurubali, Allah baraka. Thank you all very much. Allah falla party leader li fintina. You know? Yenke kilint. Na kuwa bebe tolle bulu sai. Allah fo ko. Ndolo ko fintina. President Barrow left award di molle mini alonko. Ye kato ke Gambia bankoy. It will be good. Ye award di. Ye ceremony create. Ndolo fana senna alifal senna mollo mini alonko katakuwa ke bankoy. Ka award di la. Nye long se ken na tarikol. Bolu be duma mawol long. But niyo fananke it will change the narrative. Allah baraka. Yes, congratulations guys. Allah baraka, Allah baraka. Yes, na leader sollem alanga diamu ye. Yanka kilint, yanka want. You know, yanka kilint niye just stage okay be nyo bulomut. There will be a whole lot of difference. Yes, Allah baraka.